Good morning, YouTube. Good morning. It's your girl Duchess coming back with this Rico trial today. And I'm just trying something a little bit different. I'm streaming from both channels, just getting a feel of the live space and what all I can do. Also, testing, talking over the background music and all of that piece. And I am going to close that out, stop that, and we're going to get into this commentary. So I'm streaming from both channels today, and thank you so much for joining. I wanted to tackle two things. One, give us kind of an update on this RICO trial with Atlanta rapper Young Thug and what has happened so far in this case, why I'm so interested in it, and why I feel like this is probably a case that every social studies classroom or any type of even in the economic space, just I think this is a good trial to look at with any young man age 9, 10 on up. It's a great conversation piece. It gives a lot of background, which got my interest in the lengths that the state will go to incarcerate a person, whether they are guilty or not. I'm not here to decide that at all. Um, I have my thoughts and my feedback on it, but the length that the states have gone to prosecute this case, all of the trickery and rules and violations that have happened, we are into day 125. Excuse my voice. It was football this weekend, y'all. And my team pulled out the win. But outside of all of that, just the violations and rights violations is what got my attention. So I will begin streaming at 1:30. I cover this on Break Bread with Duchess 1.0. You can subscribe at Duchess Breaks to get more trial coverage. But today may be an interesting day. We never know what's going to happen with this case. Sometimes it's a snooze fest and then it just gets popping out of nowhere. So it's up and down. But I wanted to stream from both channels because we have Antonio Sledge on the stand. And Antonio Sledge connection is one of the things it was said that Young Thug is accused of paying him to lay low after the unaliving of Donovan Thomas. So, in order for them to make this RICO charge stick, they one had to prove that Young Thug ordered the assassination of Donovan Thomas, for lack of a better term, that he had these co-defendants. It's about six of them, maybe even eight of them, but it's quite a few co-defendants in this part of it that did all of these different crimes, including drive-by shootings, well, drive-by pow-pows, let me be correct, selling pharmaceutical products. Um, I mean, there was a couple other demise situations that have happened, all in portion of this case. And they have to prove that. And despite all of their efforts and all of the low blows that they've taken, and the violation of rights, and the risk of mistrial, I still feel like they're at the losing deficit. YSL Woody, Kenneth Copeland, Lil Woody, all of those. We finished up his testimony last week. Shannon Stillwell is on trial with Jeffrey Williams, aka Thug. He is charged with the unaliving as the trigger person for Donovan Thomas. YSL Woody's testimony sheds some light into who that he may not have been the trigger man. It could have been Woody. We don't know. It could have been his friend Threat, who was demised the same weekend that Woody was held in contempt over the weekend. Could have been him. There's a lot of doubt that came into play there. And there's a lot of evidence that really was just weak. A lot of social media posts with emojis and different things. There is not any concrete evidence, and the witnesses are not proven to be viable witnesses for the state. Woody also revealed that he told the prosecuting attorneys, well, long before the charges dropped, that he was making everything up. He was just trying to keep from going to jail. He ended up going to federal prison for a GUN violation, convicted of a felony, carrying one or whatever, when he was defending his then girlfriend and newborn baby. He ended up going and go to jail for that. And he was spinning all of these lies to kind of keep from being in that space. Um, they locked him up in the mental ward of the jail twice. They claim he violated a probation to bring him in and lock him up. Did it for 2 times over 2 weeks of a period where people were eating their feces. Feces were all over the wall. It was a horrible, horrible place, trying to get him to testify to what they wanted him to, although he had told them that he was lying. Case still came forward. They even came to visit him while he was in federal prison, trying to withhold him getting a court date and um, putting pressure on him to testify to some of the lies that he told them, because they have built a case against Jeffrey Williams because of this. They even held him in contempt and threw him in, from Fulton County, hit him over in DeKalb County, starved him of his clothes, didn't feed him, didn't give him water, and then brought him into the judge's chamber to pressure him to go ahead and testify. That is, the gist. It was a lot of fireworks, but that is kind of like where they left that off. Was Woody is a known liar. He made these things up. He told them this well in enough advance for it not to even land here. And they gave him immunity of every crime that he could have committed over a large period of time in exchange for his testimony, which did not prove to be, it proved to be more on a winning side for the defense. We'll just say that. All of the trickery that they used with him, for someone who was not as street smart and had the assistance that he had, they could have been in a lot of trouble. And just the surfacing of that caused me to think about all of the young men who have found themselves in the situation where the state wants something from you, whether their tactics are legal or illegal, they want that from you, and they have power to make life miserable, to get what they want. So now we have Antonio Sledge on the stand. He is commonly known as Mutu, and he was a part of the Donovan Thomas situation, according to the state. And he pled out. So we learned on Friday that the details of his plea were not what he thought that they would be. And there are statements in there. They call them, um, it's basically like admission statements. In that plea, you are admitting to you were a part of this. You are admitting to I did this. You are admitting to several different things. They're called admission statements. And those admission statements implicate YSL, Jeffrey Williams. But there were terms in that admission statement that were not true, according to him. And he was under the impression that he would be able to address that and clear it up in court. All he was able to do was say that that's what he thought. He's also kind of toying with his freedom a little bit, because unlike YSL Woody, who did not sign a plea deal, his plea deal could be hinging on his testimony. And so there were things that he couldn't recall. Um, there was a space and time in one video where he's not in the video. You just kind of hear his voice. And he's saying he don't really know. but that is his voice there. And then when the defense crossed him, he said, yes, I was there when that video was made. But they have the power to give him the full sentence of his plea. They have the power to reject his plea. They have a power to, there's still a lot of power in the state's hands to lock this man up for as much as 45 years. He's already in his 40s. And when they left off in court before the state rested for the moment, they read off the details of the plea. Now, I looked up, and the judge is the only person that can turn his plea, basically revoke his plea, that can listen to the prosecution should they decide to petition the court to sentence him and reject his plea deal. But given the way that Judge Whitaker has kind of run this trial, um, I mean, I'm a low key fan of hers. I know she's getting a lot of smoke in these YouTube streets, but I think she's doing the best she can to honor the state's rights in prosecuting the case and giving the defense a fair share. Of course, there's going to be, teetering sides on either side of that, but I think she's doing a decent job, if not arguably a very good job of kind of staying in the middle. I don't see her throwing a book at this guy or even entertaining, because the state has pulled so many tricks, and they have been dishonest, and they will stop at nothing to get this to get this conviction, no matter how weak it may be. They violated laws, they violated rights, they've played hardball, and they're playing with these guys' freedom. So one of the tricks is they introduced a video where Thug was saying snitches doing this and they can do this and they can get unalive, YSL, blah, 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 right? They entered that with the repost date of the Instagram post, which would have been a few weeks after Donovan Thomas unaliving. The defense attorney, Brian Steele, came with the original, and that video was long before Donovan Thomas situation even happened. It was back at the beginning of the month. And the prosecution attorney was objecting, all like it was a nightmare of objections. But that is just kind of one of the tricks. So this witness is still on the stand. His freedom is very much in jeopardy. He's playing too many games for me. When he has 8 children and they could lock him back up and take away his plea deal, the defense is crossing him. Brian still is in the middle of that. We may have another hour with him. Sharp has already done his cross. And so we don't know what other defense teams will bring in, but and then the state will have the opportunity to redirect, of course. So there a lot has happened with this case, and I'm streaming on both channels just today to give my subscribers who are here for the TV and the fun and all of that piece just a glimpse into what you may or may not be missing by seeing what's happening over here in this trial and this clinic of trickery and corruption that the state is putting on bravely, no matter who's watching. And I think it's important. I think it's a good case study for a lot of our youth, because the best plan forward is to keep your nose clean and stay out of those streets. Given the environment, it's hard to do. I totally get that. But I think from a community perspective, it's a good case to kind of watch and see what could be happening in your community, in your schools, in the court system. Um, you know, what's kind of happening under your nose. This is the DA of Fulton County. She's the assistant DA, of course. but they have violated rights, rules, obligations, and they are officers of the court. And if they will do this under public scrutiny and put on a case like this under public scrutiny, I mean, one would have to wonder why things are so crowded in the judicial system and in those jails. And the inhumane treatment is just enough for me to be here for 2 days. But I'm only streaming from both channels today. Um, Hopefully, it'll be some good entertainment. And, uh, I get started later over there at about 11:30 or so we can kind of bypass the breaks and all. So we're already into 11:30. My good friend Amy may or may not join us today. We've been kind of in this trauma bonding of YSL and everything that has been going on with this case. So without further ado, I am going to mute the mic and we are going to get started.
Well, okay. Good morning, everyone.
Good morning. How are you doing? How are you?
All right, was everybody able to get the transcripts that were forwarded by Ms. Winfrey and by Ms. Weaver? Okay,
Yes, Your Honor.
great.
Okay, so what's happening here? Court started at 8:30 today instead of 9. So all the attorneys and the defendants are there. The jury is not present. They have some pieces to sort of hash out. And when they need to do that outside of the jury time, and it's normally around a ruling, someone's trying to get some evidence in, or someone wants to have a line of questioning that the other side may think is not appropriate or shouldn't be included. So a lot of arguments happen when the jury is not in session, as well as those that go down when court is fully in session. So we're about 30 minutes before the jury will come in and the witness will retake the stand, and Brian Steele resumes his cross. Okay. I just wanted to kind of bring you guys up to speed on that, and we'll get back to the stream.
And I don't know if y'all got word, Ms. Love is a little bit delayed this morning. Mr. Atkins, are you able to point to where in the transcript supported Ms. Love's argument on that objection?
Your Honor, I am currently not able to point to exactly where in the transcript supports the state's argument. I will be working on finding that, Your Honor.
Okay, or can you maybe communicate with Ms. Love about
Yes, Your
it?
Honor.
Okay. Matters for the court's attention this morning.
I think it's part of this. I just want to continue my argument on my motion, that's all. But I assume it's within what you're doing.
What do you mean?
I assume it has to do with what you just asked, Mr. Atkins. So I think it's part of the same motion, but I have other statements that I'd like to make to the court. That the court to consider, that's all.
Okay.
I could do that now. I'm not trying to blindside Mr. Atkins, but if it helps, I'll do it now.
This gentleman that we're looking at right now, his son is a part of their defense team as well. They practice, and he looks
So the
a lot like
8:30 email that I guess y'all all got says she'll be here momentarily. Not quite sure what momentarily means. But
Yeah, Your Honor, my latest update is they should be in the elevator as I'm
Okay.
speaking.
well, then we'll just give them a couple of minutes.
Thank you, Your Honor.
And does everybody that needs it or wants it have the Zoom link?
When was that sent out, Your Honor?
Should have been probably this morning. I think I can copy it and send it on that email that just got sent around if anybody needs it.
Thank you.
Okay.
Your Honor, may I also be copied on that email?
Yeah, I'll just send it to everybody that's on the email from
Thank you, Your
on
Honor.
behalf of Ms. Love. I don't even honestly know who all these people are. Some of them might be DA's office people. Good morning, Ms. Love.
Your Honor, I think that, one person, you only had, we can find out exactly who.
Y'all might be getting an email from Ms. Pursfield with the same Zoom link as well.
Under a wholly unrelated matter,
Okay.
would you just consider possibly not holding court on election day this year?
I'll consider it.
Thank you. That's all I ask.
There are 2 weeks of early voting, though.
I volunteer at the polls. I could find someone to sit in for me, obviously, so it's not a major issue, but
Okay.
I just wanted to put that out there.
I appreciate that, but considering all of the early voting opportunities, including weekend voting, I don't know that I'm gonna cancel court for a day. I really would like for us to move as expeditiously as possible through this case. I don't think we want to be here this time next year doing the same thing.
I'm never one to argue against that, Your Honor.
Your Honor, while the district attorney is setting up, can I follow up on that?
Sure.
My office should have sent your honorable court an email about, I believe it's the same day, November 5 is election day. I was given the honor of arguing a case before the Honorable Supreme Court of Georgia, Georgia State University that morning. So I have to clear it with your honorable court, but I just want to, I have to let the court know.
Okay. I'll let y'all know. I haven't seen that email yet, but I'm sure it will get forwarded.
It was sent to Miss Percifield, but we could, and Miss Ross.
I'm sure that they'll send it on to me. You may.
Yeah.
Yes.
If I may first report with, Ms. who we are on, last year's.
Oh, it's fine. I just was sending out the Zoom link on the email that your, I guess, assistant had sent. It's fine. I don't need to know. I appreciate it though.
Your Honor, I believe that we were awaiting a transcript, and if I got that this weekend, my apologies to the court because I was under the weather this weekend and I did not see the portion of the transcript that reflected exactly what it was that I said in response to a particular exhibit.
Okay, well, that is in the transcript that I think Miss Percifield forwarded on Sunday afternoon. I can
Thank you.
read it out.
I haven't, if the court will
It's
permit me,
pretty close to what my memory of it was, actually. You say, Your Honor, but there is a difference that matters. It's a distinction with a difference because what Mr. Steele was putting up is a picture of Defendant Williams with a young man whom evidence has come out did not associate with Defendant Williams after a particular time. So can you point the court and defense counsel to the portions, and I know we don't have Detective Dennis's transcript yet, but we have the transcript from Mr. Donovan Sr. You should have gotten that forwarded from Ms. Weaver. Have you had an opportunity to look at it yet? Okay.
And while we are looking for more specific language, I just want to point out to the court that to the extent that the objection is made that there was a comment on the evidence or the evidence saying a particular thing, two things as it relates to what I said. I intentionally did not speak a particular name for multiple reasons. And I was particularly vague for multiple reasons. But the objection that I had was that Mr. Steele asserted through his language that that particular flyer was introduced in 2015, and that was put forth before the jury more than once.
Right.
And Mr. Sledge agreed with that. And Mr. Steele then put forth a flyer that he said would have chronologically come after that flyer that I had the objection to. And that flyer that he put up was one from December 2014. So this is not a circumstance where I testified. I alluded to, I made reference to something that I believe existed. I did not comment on, what that evidence was or make a comment on the evidence. But unlike a circumstance where a lawyer would say, that didn't happen to a question being asked, I simply said the evidence, there's been evidence. I didn't say what evidence. I didn't comment on a particular piece of evidence. And so in as much as my statement to the court was intended to orient the court and to apprise the court of why I was making the objection without speaking too much about it, I would ask the court to overrule Mr. Steele's objection to my objection and deny any motion that he made as a result of it. But we are still, at the court's direction, looking for the language that led us to be where led me to make the statement that I made.
Understood. And Mr. Steele, looking back, and when we were talking about it Friday, you said you weren't sure that you had said 2015, but looking back on page 10 before the objection by Ms. Love, you do say you don't say, but you're asking, is that 2015? And the witness agrees. And apparently everybody knew it was 2014. So.
May I speak?
Sure.
So I agree. I misspoke. I did not do it intentionally, but that's for the court to determine. And Ms. Love, I hope you feel better.
Thank you, sir.
My issue goes to three things, really. And the reason, and thank you for allowing me not to ask the jurors to be removed. I don't remember the time, but it was close to 5. And I just didn't think it was appropriate.
Sure.
But I appreciate you allowing that to happen and that it's still preserved. My issue, though, is this. I definitely misspoke. I watched the Law and Order or whatever, Law and Crime, and then I got the transcript later. And I apologize. All that has to be said is, where's the date on it? Ms. Love said that, or are you certain, or do it on redirect? And then I corrected it because I said this is in date order. And then I went back to the next flyer is the same band, same group performing, and it's December 31, 2014, going into January 1, 2015. I wanted to correct it. I didn't realize at the time I said 15. I wasn't focused properly, I guess. But for a lawyer to then say, and the evidence has shown, that was my issue.
Yeah, I understand what your motion addresses.
And this is easy to figure out because I can't get these Twitters anymore. They're gone. They won't. I tried to subpoena them. I can't get them. But the state, through Agent Racy, he's a Cobb County, he's now with ATF, but he was with Cobb County. He got I don't know why, but just a certain amount of time from middle of 2014 to the middle of 2015. Got a year. All these are dated. The reason that these aren't dated, I put in, is because previously the state had an objection to any writing on it, but everybody has the date. It was December 26, 2014. and December 31 going into January 1, 2014, 15. But my problem is we can't be making any lawyer what the evidence is until a closing argument, and the evidence is not closed yet. So that's my big problem. And I will say this. The state gave us an email. If they don't remember it, I could put in evidence for it, just for the record. On Friday, August 9th, 2024, at 5:22 p.m., Your Honorable Court is CC through the Honorable Miss Persifield, and it gives the list of people who are going to be testifying. That's wrong. That's the wrong date. I gave the wrong date. I'm looking at the wrong date. I'm sorry. This was given the way it used to happen. I don't know if it still is, but Miss Hilton would give a list every Friday to the media and then to us of who the next witnesses are, and certain witnesses, for whatever reason, couldn't be shown.
Right.
So they were undercover agent or something like that. And then there were objections there too. But on the media list of 5/10/24, so it's May 10, 2024, the state had Detective Racy, which is RAISSI, by the way. He's now Agent Racy. And then followed by this performer, Mr. Lamar. His first name is DEQUANTES. And he goes by Rich Homie Kwan. And that came to everyone via email from Ms. Hilton. That's May 2024. So my point is, the state had him on a short list. They didn't call him. They don't have to call witnesses. I get that. So I was going to call him. He's already under subpoena. And I assume the state knows this because they didn't call him. But on March 23rd, 2015, Mr. Lamar, or Rich Homie Kwan, and this is all public, he said, I'm still affiliated with Rich Gang, with them, I'm talking about Rich Gang. In an interview that was with Thesis, THISIS 50. In an interview with ESPN on April 20th, 2015. And 2015 is right after the January 2015 the death of Mr. Thomas. Mr. Lamar reaffirms that Mr. Williams will always be his, and I'm quoting it, brother. And with Vlad, VLAD-TV, Mr. Lamar talks about Mr. Williams on April 21, 2015, wishing Mr. Williams the best. In an interview, he states that he and Jeffrey have no, or excuse me, Mr. Williams have no, quote, bad blood. That's May 16, 2022. September 18, 2022. He talks about that they get along. In an interview with Cam Newton, August 15, 2022. He details how he's a fan of Mr. Williams' work even before they met. And he emphasizes that he and Mr. Williams never had a problem. And it goes on. He has other interviews here. The point I'm trying to make is I contest that there was this supposed eruption and they don't get along. So the state put up Mr. Donovan Thomas Sr., they said last week to this honorable court, to make this claim. They don't put up the actual people involved. And I'm going to put up, if I need to, I know I don't have to put up a case, but if I need to, I'm going to put up people who observed the two of them together. The people who interviewed him, I know I'm going to get objections to hearsay. But the point I'm trying to make is to say that I said the wrong date doesn't need this additional. That falls on the exact same platform as with the same witness last week. District Attorney Love read a plea colloquy in an unrelated Alford plea. I don't know how that happened. That's from Mr. Sledge. And then I believe, and it's not a violation because I try to speak with every witness. If they won't speak, that's fine. But at that June 9th, 2024 meeting at Starbucks in Fayetteville, there was clearly Brady evidence. Now, some of it was given to us. The Brady evidence that was given was what I originally said. It was August 9, 2024.
So, Your Honor, if we could deal with one issue at a time, I don't have any problem addressing each of them. I would ask the court's indulgence to allow me to address each one in turn because I've heard about 4 so far, and we're on to Brady evidence at Mr. Sledge's interview, which is entirely different than the exhibit Mr. Steele put up that we were addressing.
All right, well, we were trying to give you time to find the portion of the testimony to support what you said on Friday. I think Mr. Steele's just outlining what his other issues are going to be.
Because I'm going to have to address each of those, and I do have a response to each of those, I was trying to listen and to take note.
All right, we have 2 other people sitting at council table with you. I'm sure they're equally capable of running a word search and a transcript. Go ahead, Mr. Steele.
It's just that, at this meeting, it comes out that Jeffrey Williams is with Mr. Donovan Thomas days before he's killed, according to Mr. Sledge. I have other evidence that puts them together, but that's the contested part. It's not really Rich Homie Kwan, it's Mr. Thomas, Donovan Thomas. And what the state's trying to say is that for the court's edification, I believe this is what they're saying. Mr. Thomas is trying to be the manager of Rich Homie Kwan. Mr. Thomas doesn't want Rich Homie Kwan to sign with a man named Mr. Brian Williams, who's Birdman. Jeffrey Williams is not signed with Brian Williams, Birdman. And somehow Jeffrey Williams doesn't like the fact that Donovan Thomas won't let Rich Homie Kwan sign with an independent person. So Jeffrey Williams has him killed. The jurors may adopt that. But when Mr. Sledge tells District Attorney Love on June 9, 2024, that Jeffrey Williams and Donovan Thomas were outside, and I thought it was TIG, but TI's studio. He's a performer he's a wonderful performer named Clifford Harris in Atlanta. And they're having a good time. That's Brady evidence. And I never got that. Now I did get, I don't want to, there's no violation. I'm making it clear. I got it from Mr. Sledge and Mr. Wright. But we should have gotten it from the DA as well, because they didn't know, I assume, they didn't know that I got it from other people, and I don't think Mr. Matthews got it. I didn't share with him anyway, so that's Brady evidence for him too, because it's part of the state's case. Those are my issues. That's one witness last week, and it's the objection, it's the Brady, and it's the reading of a transcript. It's just a lot to deal with. And that's it. My objection, I asked for a mistrial. I'm God willing honest with everyone, but I don't want a mistrial. But I don't know what to do. So those are my issues.
All right, thank you.
And I do apologize for the speaking, and hopefully I cleared it up.
I mean, it happens. I don't find any purposeful action on your part in saying the wrong year. But
Thank you, Your Honor, for allowing me the opportunity to speak. I apologize to the court in advance. My voice is a little lacking today, but as we are bringing up things and patterns, I want to bring to the court's attention a couple of things that the court would not have knowledge of, as the court could not have been present when it occurred. I've read the portion of the transcript where I said, as it relates to a young man in the picture, I believe evidence has come out that, and I want to read it exactly as I said.
well, I mean, I already read it out once.
Mr. Steele was putting up is a picture of defendant Williams with a young man whom evidence has come out did not associate with defendant Williams.
I'm going to pause for just a second just to make sure we're all caught up and following what's happening, because I feel like it's a lot happening. So just really, really quickly, there is a video evidence of Young Thug and Moontoon in the background, Antonio Sledge. He's the person that's coming up. He's the person that is on the stand right now that the defense is crossing. And Love and Steele, who obviously, for so many reasons, it's just spilling out that they don't care for each other and they don't see it for each other. The judge kind of, gave them a little, kind of like a pep talk, I guess, to try to divorce their issues and focus on the case because it doesn't look good for either of them, really, or either of their clients or whatever. And in this evidence, Mr. Steele is saying that the dates, this happened well before the Donovan Thomas thing, whereas Ms. Steele introduced the evidence to the jury as if it was days after. And now they're talking about this Brady violation again and supposed to give them all the pieces that they need to be able to respond to these cases. And this Starbucks meeting that happened, could that have been a Brady violation? And then they got some more testimony that the state was going to use that was kind of new to them from what I'm following. And so they both have arguments. And Miss Love has an argument, and they've been searching for 2 days now. I'm exaggerating, but they are waiting for her to get to the script, like the piece in the script where he said what you said or you didn't say what you say. Like they got to look at this transcript and all of that. So that's what they're waiting on. And that was so funny to me when Judge Whitaker was like, I think someone can do a search for a word in the script. You talking about you trying to pay attention and you want to wait. No, you want to waste some more time, girl. Let me stop because she did have a YouTuber in her courtroom and I don't want to meet Judge Whitaker like that. So I'm going to play nice. I'm going to take a comment. Oh goodness, I believe he misspoke. New Year's is tricky. I think he did. It kind of depends on how you think of it. Easy to get the year wrong. That's about Brian Steele supposedly doing something intentional. And the reason why Miss Love is so sensitive, because she's done it throughout this whole trial. And it's crazy how she can't take it if it's given to her. So for me, if he got one in on her, good job. Like you need a little dose of your own medicine because of what you putting us through over here with all these tricks. On the other hand, it's real easy to misquote. I don't think he would play dirty like that. The way he has been about the law, I don't think he would play dirty like that. And I think he wants to win this thing fair and square. He's fighting. So, for his client, of course, but I believe you. I believe he misspoke. But if he did, I mean, can you blame the guy? Considering. Anyway. All right. I just kind of wanted to bring us up to speed. He gave us a laundry list of some other things just while they wait, but they're really only addressing this one argument between the two of them. All right, let's go.
After a particular time, a particular time. So there have been instances during this trial with other witnesses, much like the way that Mr. Steele is alluding to instances that the state has brought up. I'm bringing this up for a reason, if the court would give me indulgence, where the state has asked a witness a question. For instance, did Mr. Steele stop the recording while you were talking? And Mr. Steele literally verbally stood up and said, that didn't happen. That did not happen. See right there. And so giving testimony during trial, I did make an objection to that. That was addressed. That, in my estimation, is wholly different. And that is the kind of thing that it would appear Mr. Steele is sort of alluding to the state having done now, and it's not. I did not state anything about the weight of the evidence. I said vaguely as I could, I believe this has come out. The jury will know. My objection was intended to inform the court as to why I made that objection. I will point the court's attention, since Mr. Steele has brought up these interviews he's talking about, to the discovery we did provide.
You know what? He admits there's not a violation. So have you found the portion of the transcript that you say supports your assertion that evidence has come out that whatever?
Since I didn't name a person.
I understand, but then you said to me
I did.
afterwards, outside the presence of the jury, I've got a basis for saying that.
And I did.
Okay.
During the examination of Donovan Thomas Sr. by Miss Hilton, she asked whether or not Mr. Thomas Sr. ever saw this person, this gentleman that I was referring to,
Mhm.
and defendant Williams perform again after December 2014. He
Okay.
said no. That was the evidence. That is the reason that I said that evidence has come out that these people didn't associate after a particular time. I intentionally did not want to speak on 2015, 2014, but I can state in my place that unlike interviews and all of that, we've had interviews by people other than counsel in the courtroom. We've actually had interviews where we have had investigators told that after the murder of Donovan Thomas, that this gentleman and defendant Williams did not speak again, period. After they saw each other in Miami following the murder of Donovan Thomas Jr., a question was asked, where is Woody? Defendant Williams told this person, Woody was in Atlanta. This person looked over and saw Woody on a turntable or something in that same club, and this person walked away and did not say another word to him afterwards. The point that I'm making is that when I see an assertion by counsel that there has been something, a concert by the two of them in December 2015, and the statement wasn't made, it's a leading question. So it's essentially a statement wasn't made once, it was made more than once. And then the witness adopted it and said, yeah, it was in 2015.
All right. So
I don't know
I
any
think
other
I
way to
see the
correct
portion of the transcript that you might be referencing. It is on page 45 of the rough of Mr. Donovan Thomas Sr.'s testimony. There's a question about a video shoot in Birdman. After this video shoot, to your knowledge, did your son ever promote anything dealing with Jeffrey Williams? The answer after the Fulton Industrial video shoot, no. Is that what you're talking about? Or is it something else?
think it
Because
was
it would
more
be nice if
specific.
y'all could point me to the part of the transcript. But you know what? Regardless, I think that the issue and the reason that Mr. Steele made the motion is because you said in front of the jury, and I hear you saying, Mr. Steele did the same thing, which honestly, y'all, neither of you, that if it is improper, the fact that the other person is doing it doesn't make it less improper. Two wrongs don't make a right. Y'all are familiar with that. But I understand that you were trying to correct the misstatement about the date and essentially say, you know, it's not possible. The better way to have done that would probably have been to say, can we approach and call to Mr. Steele and the court's attention why it is that what he was saying about 2015 wasn't possible. So I don't think that it is anything that is serious enough to warrant a mistrial. But for both of y'all, for everybody, if something like that comes out and you think for whatever reason that something is getting misstated by the attorney, just ask to approach and we'll deal with it up at the bench. Okay.
Your Honor, there is a,
Can I get everybody's okay on that?
absolutely.
All right, great. Go ahead.
Thank you. There is an issue that I have experienced. I have made an objection, and when I hear an objection, if the objection is made to my question, I pause.
Yeah.
But that does not happen. And so if when I object, a person continues to talk and improper information is being put before the jury, I don't know what else to do.
Okay.
If that,
I'll address that. So I noticed that as well. Everybody, when you hear the word objection, stop talking and let me hear what the objection is. And then sometimes I will still need to hear the entirety of the question because I won't know whether the objection is meritorious or not, because I'll need to hear the rest of the question. But not always. So just stop what you're saying. Let me hear the objection. And then if I need you to tell me the whole rest of the question or whatever it was you were saying, I will let you know that. And then you can, and then I'll make a ruling. Can we operate like that from now on as well? Great. Okay. We ready for the jury now? You need a minute? Yeah. Okay. Sure. We'll take just a minute. Yes, just, we're early on, but does anybody else need to step out? Do we need, like, with regard to the defendants? Yes? Okay. Everybody go to the bathroom. Come back, let's get going.
Okay, I'm just gonna, while we're waiting, I'm gonna fast forward through this break that they're doing, but okay. So it sounds like Miss Love then had us, looking for this place in the transcript, and there really wasn't anything there. I can't. I'm like, wait a minute, what was the ruling? But it sounds like she got it wasn't. It's not a ruling. It's not a. She lost that argument, whatever that was. The judge, I'm interested to just see how she is gonna manage these two heavyweights, because Brian still knows the law and he is on their neck, and Alan Sharp back there, he's not letting them get away with anything. They'll slip it by him to get it in, but he's definitely gonna run that thing back. So, child, talk about a soap opera. It definitely is a soap opera. But was that a argument for the state to get a mistrial? Girl, it's been a mistrial since y'all talked to Woody back there, and when he was in the feds, and he told y'all he made this mess up. Like, this is what this looks like, a made up case. Anyway, what is going to be the thing about this photo situation, or is it going to affect Sledge's plea agreement? We're getting ready to get Mr. Sledge on the stand. She needs to at least get those plea deals, but you can't even trust them considering what's going on with Sledges. All right, you guys, we'll get them back from the break a little bit faster. Hey, Amy, did you have a good weekend? Girl, I had a blast. Not really, but football was on, so I was elated. Elated, elated, elated. I had a great weekend. I hope you had a good weekend. We'll get going.
Okay,
Brief, Your Honor.
that's fine. Okay,
Brief, Your Honor.
that's fine. Good morning, Mr. Sledge.
On. Yeah.
tell her safe is down in her half on the bridge.
All right, thank you very much. Good morning, ladies and gentlemen. I hope y'all all had a very nice weekend. Mr. Steele, I believe you were finishing up your examination of this witness.
Your Honor, may I approach Mr. Sledge?
You may.
Mr. Sledge, may I approach you?
Yes, sir.
I'm showing you what I've marked as Mr. Williams or JW 255. Would you take a peek at this for me? Tell me whether you recognize that item.
Yes,
And is it in the same condition? Have you seen it prior to, 2024, 2023, going back? Is it the same condition?
yes.
Any alterations or changes to it that you can tell?
No, not allowed to see.
Your Honor, I move for the admission of Mr. Williams 255.
It's admitted.
May Mr. Kokomo display it, Your Honor?
Yes.
It should come up on your screen, but it should be the same exact thing. You could check it. That's in front of you, okay?
Yes,
And if Mr. Kokomo can blow that up at all, and if not, that's fine. So this is exhibit number at the very top, Mr. Kokomo, if you just show, you see where it says exhibit or EXH number JW, Jeffrey Williams 253? I believe it's 255, but. Let me see if I can. All right, you see at the very top, 255?
yes,
Okay, and then if Mr. Kokomo can just center so all the words can be seen on the actual writing. Do you recognize this as a social media posting? And do you see the date?
yes,
And it's from DMAC, got me to TOO, banging at DMAC to banging. You see it says December 27, 2014.
yes,
And does it read then, and I'm changing it just because that's how I am, A-N, lie to their mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, 3 question marks. I don't get it. And then hyphen at Young Thug. Do you see that?
yes,
All right, did I read that fairly accurate? I know it wasn't perfectly accurate, but fairly accurate.
yes,
All right. And is that similar to what has been marked and played in states number 447Y, where you started out with, I'm going to, and this may not be exact quote, but something like, I'm going to swear to tell the truth. I'm going to lie on God. You remember that?
yes.
All right. Can you tell the jurors what it means, if you know, when it says at the end of it, the hyphen at Young Thug?
Before it,
Can
I
you,
don't-
can you explain that to the jury?
I don't get it.
Yeah, right after that.
At Young Thugger Thugger. I mean, Young Thug, I'm sorry.
Yeah, do you see that?
Yes,
Do you know, and if you don't know, just say, I'm not sure. Do you know what that means?
no, I don't
That's
know
fine.
exactly what it means.
Okay, and this one goes back, if you remember, and if you don't, we can show it to you. But do you remember what the state used on January 26, 2015, said repost? You remember that?
The repost whiz,
Yes.
yes,
Okay, and then you showed the jury the January 4th, 2015 video, same video, Jeffrey Williams, you remember that?
yes,
And this one is approximately a week before January 4th, 2015, right?
yes,
December 27, 2014.
yes.
And prior to this, prior to 2014 and 2013, 12, going back, have you heard the same type of statement?
Yes,
All right. Now, did anyone from the police department or the district attorney's office, and I'm saying after you entered a plea, so this is December 28th, 2022, okay?
yes,
After that, so coming forward,
yes.
did anyone from the district attorney's office or one of their teammates, police, whomever, did they ever ask you,
Objection. Relevance as to what anyone else ever asked this witness. If Mr. Steele wants to ask something, he can.
What's the relevance?
ask about the evidence of the reposting? They showed the gentleman the evidence?
Your Honor, my
Know if
objection.
anybody, I want to know if anybody ever went over with him that it's a repost?
Your Honor,
Sustained.
Did, at your meeting, we'll just do it on June 9th, 2024 at the Fayetteville Starbucks?
Yes.
Did District Attorney Love ever ask you
Objection.
about,
objection.
An objection.
Yes.
Sustained.
did State's Exhibit number 447Y, the repost, January 26, 2015, was that ever discussed with you?
Objection, Your Honor.
Sustained.
Where it says on the January 4th, 2015 video, and if you need to see it, I'll show it to you. Do you know what I'm talking about?
Yes.
Okay, where you read to the jurors that Mr. Martinez or Duke said it first?
Yes.
Remember that? Okay. Did you ever explain to anyone about Mr.
Objection,
Martinez
Your Honor.
saying it
That would be
first?
hearsay.
He's right here.
Explaining outside the court, it would be relevance and objection.
Sustained.
All right. Now, District Attorney Love asked you on your direct examination why you didn't go to the police on the morning of January 11, 2015, when you dropped off Mr. Copeland at the City of Atlanta Police Department homicide. Do you remember that question?
Yes.
All right. And you were aware that the police called Mr. Copeland
Yes.
that night, and then Mr. Copeland went down to see the police, right?
Yes.
Did the police call you and tell you that you were the prime suspect?
No.
Objection to the compound question.
Overruled.
No.
You were asked questions about the music company or business YSL, direct deposits. You remember that, working for them,
Yes.
working for Mr. Williams? You remember all those questions?
Yes.
All right. Do you personally know, do you personally observe, does that music business have lawyers working for them? If you know, if you don't know, just say, I don't know.
I don't know.
All right. Do they have accountants?
Yes, I think they have accountants though. I know that.
How about managers?
Yeah.
Objection, Your Honor, vague as to managers.
Overruled.
Yes.
Now, you were asked a lot of questions also about what you explained to the jury, that anybody can claim YSL. Do you remember all those questions?
Yes.
There was no beating in, there was no initiation fee. Remember those type of issues?
No. Never have. That you never have to get beat in or however.
Somebody could just say, I'm with YSL.
Right.
By doing that, does that mean that they're with the record company YSL?
Objection, vague. By doing that, I don't know.
Overruled.
Now, you mentioned yesterday meeting with Jeffrey and Mr. Brian Birdman Williams and yourself and Mr. Donovan Thomas and others, I'm not excluding others, shortly before, God forbid, Mr. Thomas was, days before he was killed on January 10, 2015 at TI Studios. You remember that testimony?
Yes.
Is TI the performer TI that you're talking about?
Yes.
Do you know his real name?
Something Harris. That's all I know. I know his last name Harris.
Mr. Harris?
Yes.
And is he a phenomenal, well-known, accomplished artist?
Objection, Your Honor.
Sustained.
You were asked about the definition of snitching. Do you remember that?
I don't remember asking me that.
All right. Do you remember saying in the video 447Y snitching, and I'm not gonna say, but BIT blank H?
Yes.
Okay. And tell the jury what snitching means.
To me, my definition of snitching is another person lying on another person.
Now, on from December 28th, 2022, I'm using that date because that's the date that you were released from custody on this case. That's the
Yeah.
date of your guilty plea, okay?
Yes,
All the way through today, but including Sunday, June 9th, 2024, when you met at the Fayetteville Starbucks,
yes,
the district attorney and your lawyer and the investigator. Did anybody go over with you what's been gone over with you in court, the plea agreement?
no,
You told the jury that Jeffrey idolized or idolizes Lil Wayne or Mr. Dwayne Carter. Do you remember that testimony?
yes,
Did you ever hear, are you familiar with Lil Wayne's work? His music, his anything?
yeah, I'm familiar with his music.
Have you ever heard him use the word slime, the term slime?
Yes,
Was that before you ever heard anyone say it, or was it after?
I had not heard it said before, but he's like one of the first artists I heard say.
He being who?
Wine, the wine.
Okay. Your Honor, I don't have any other questions.
All right, Ms. Weinstein, you had three cross.
Thank you.
Yes, Your Honor.
Brad.
Good morning, Mr. Sledge.
Good morning.
My name is Doug Weinstein, and I'm Diamante Kendrick's attorney.
Yes,
May I approach you and show you something?
yes,
Thank you. I'd like you to just take a look at this video. Do you recognize the action that was performed by that player in that video?
yes, Tyrone here.
Hang on,
Testimony
don't say
about
anything
it.
about it yet.
I'm sorry.
Excuse me, just do you recognize that
Yes,
player?
yes,
Do you recognize the action that he performed?
yes,
Okay. Your Honor, I'm moving to admit Kendrick 1.
I object on the basis of relevance and foundation, and if we need to approach so that Mr. Weinstein can show the court what it
Well,
is.
Yeah, I haven't seen it, so
Okay.
I don't think we haven't given out our.
I need to step out. Okay.
Sustain on the foundation, but you can see if you can lay further foundation.
Thank you, Your Honor.
Mr. Sledge, I have a few more questions about that video that I showed you.
Yes,
Have you seen that video of that player before?
I know who the player are.
Have you seen him doing this particular thing? Have you seen that clip before that I showed you?
I don't recall seeing the clip, but I just seen it when you just showed it to me.
Did you watch the game yesterday?
I didn't watch Miami game yesterday.
Okay, I'll move on.
All right.
I'm going to show you something else, all right?
Yes,
May I approach?
You may.
You see this photograph?
yes.
Have you seen that photograph before?
No, not to today.
Okay. And I will not be asking you questions about that photograph.
Right.
December 28th, 2022, going back to that date, where did you wake up in the morning?
At Fulton County Jail.
And where did you wake up on January 1st, 2023, New Year's Day?
And at home?
At your home,
Yes,
in your own bed.
yes,
And you signed that plea deal that we've already talked about.
yes,
And you initialed all those statements that were made in there, right?
yes,
And you would have initialed anything to get out of jail on that day, correct?
yes.
If they would have asked you if you could say that YSL did
Objection
not kill
calls for
Tupac,
speculation.
What's the question?
if they had asked you,
Objection
If
to
you-
if they had asked you, just nothing else beyond that, Your Honor, because it's speculation.
Sustained.
but again, you signed and initialed all of that, and you would have signed and initialed anything to get out
Objection.
of Rice Street,
Sustained.
correct?
Asked and answered.
Sustained.
No more questions.
All right. I think nobody else had cross. Is that right? Is that still the case? Okay. All right. Is there redirect?
There is, Your Honor.
All right.
Mr. Sledge, you were asked quite a few things by Mr. Steele on Friday regarding what was and what was not asked of you at the time that you entered your plea agreement with the state. Do you recall that?
Yes,
Your Honor, just
Yes.
to satisfy the rule of completeness, the state tenders State's Exhibit 444Y, the entire plea agreement, or states 1AS, which was admitted for a different purpose at a
All
different
right.
time.
Any objection? Okay.
Your Honor, I would object to further commentary unless we need to approach. I'm tendering the exhibit.
I understand. He's not commenting. He's stating what his objection is because I asked him to. I think we might need to approach to resolve it, though.
All right, so they're approaching on Steele's objection. Miss Steele, I'm sorry, not Miss Steele. Miss Love is in this pink, and she's trying to soften herself up a little bit, maybe even waiting on some sympathy. She was late for court today. She didn't feel well this weekend. I found myself wondering, was she watching football like me? Anyway, she doesn't look too good in front of the state. I think that Woody situation kind of set things in motion for the side, of course. And we're on day 125, long before they agreed to be, you know, long after what they initially signed up for. And then this plea agreement and this Moonton situation, and he's also all in that script. And now we have an evidence date issue, like all of her objections. She doesn't look very good in front of the jury, in my opinion. So she's now trying to not let any resemblance of the way she's handled herself in the courtroom show up in the defense's presentation. But the judge did say just because one do it and the other one does it doesn't make it correct. So defense needs to operate, as true officers of the court. But yeah, love is looking, it's not looking good. So I'm with Steele. You really don't want a mistrial the way defense is kind of, the way they're scoring on this, despite all of the state's tricks and all of their exposure. But goodness, they're going to soon leave them no choice. And then the state was arguing that. Okay, let's take a comment. Miss Love reminds me of that one friend that never apologizes for anything. After a while, the hypocrisy becomes too much. Exactly. I agree with you. Um, and then she complains about the same tactics. Why? Because she knows that's what she does. So I'm going to fast forward. We'll see who won this argument here. And she's in her cross. She is closing out that plea deal that they made, making sure that's in evidence. And shout out to the defense team that has laid a good foundation in the script of the things that are untrue in that plea deal, as well as the circumstances surrounding that plea. There are things for the judge to consider that may be helpful for him should the state find themselves displeased with his testimony and revoke his plea and send this man to jail for, I mean, we don't know if it's 35, 45, or 50, but it's a long time. Yes. All right. So let's see who won this argument. We'll keep going. Oh no, I messed up. Wait. Hold on a second, y'all. I'll be right back. All right, y'all. I'm back. I messed up. Doing too much, and I messed up. So let me get this back up here for us. And we're gonna get them past the break. Child just doing too much. Oh, and we're getting into football. Thank you. I clicked the whole thing off, so we're back where we started. Or I was panicking, like, what did I do? Just doing too much here. But before I get started, yes, I only watch college football too. See, this is why we're friends, Amy. This is why we jail. Outside of being the moms in the courtroom, I follow college football too. That's all I watch. I divorced the NFL in the 90s. We'll talk about that later. Back to court. Wait, y'all, I still may be at the wrong spot. My goodness. Oh, this is a bad one. Okay. I'm always doing something screwy on a live. I'll get it though. So let me figure out where we are. Love was up and we have this argument going on. So let's see.
States 444Y and states 1AS. And today, were you asked that question on cross-examination? Thank you, Judge.
Okay. I saw they were at the sidebar. It was her and it was before she took over, wasn't it? Help me. Know where I am.
Go ahead, Ms. Love.
Thank you, Your Honor.
We did get to her entering that into evidence. I think I'm still before it.
Mr. Sledge, on cross-examination just now, I believe it was by Mr. Weinstein. Forgive me if it was by someone else. Were you asked the question whether anyone ever went over the plea agreement with you between December 28th?
Amy, I feel like I'm before it. I can't remember what they went to. What did they go about? I think I'm before it. Let's see. Yeah, that's where they are here. So we never get to hear what the decision is. That's the problem.
And let's get Mr. Sledge back, please.
Thank you, Judge.
Okay, so that was the sidebar. She did. She objected to the new lawyer dude. Right. And she objected, but he was kind of done anyway. Okay. So we're catching ourselves up here. And then I guess we don't get to hear whatever the sidebar was about. She was introducing that part in.
Go ahead, Ms. Love.
Thank you, Your Honor.
Okay. So she's starting with his plea and what he testified with the defense. Let me gather myself and make sure this goes.
Mr. Sledge, on cross-examination just now, believe it was by Mr. Weinstein. Forgive me if it was by someone else. Were you asked the question whether anyone ever went over the plea agreement with you between December 28th, 2022, when you signed the document that is states 444Y and states 1AS, and today? Were you asked that question on cross-examination by either Mr. Steele or Mr. Weinstein?
I don't know. I don't think Mr. Steele asked me that. He asked me something about June the 9th. So I don't know if Weinstein just asked me that question either.
All right. Did Mr. Steele ask you on cross-examination whether anyone went over that document that you signed on December 28th, 2022 with you at the June 2024, I believe it was, meeting between you, your attorney, investigator Lancico, and me in Fayette County? Did Mr. Steele ask you that?
I think that was the question was.
And was your answer no?
Yeah,
No one
because
did.
no, yes.
At that point, had the document already been signed in its entirety? Had you already signed everything you needed
Oh,
to
yes,
sign?
yes.
On cross-examination last week, you were asked about hiring an attorney for the purposes of this case. And let me actually back up and ask you this. You were asked a few questions about what was going on at the time that you signed this plea agreement on December 28th, 2022. Do you recall that?
Yes,
All right. Do you recall being in a courtroom here in Fulton County on the date that you signed that plea agreement on December 28th, 2022?
I don't think I was in the courtroom. I think I was in the tank in the back when I signed.
Okay. Were you in a courtroom when you acknowledged under oath that everything that you signed was true?
Yes,
Did Mr. Steele, Mr. Shart, or any of your other friends' attorneys ask you on cross-examination?
Sustained.
Okay. Did you tell the jury that you loved Mr. Steele? You loved Shannon?
yes,
Did you tell the jury that you loved Defendant Williams?
yes,
And Mr. Stillwell and Mr. Shart and Mr. Williams, they represent people that you love, correct?
yes.
All right. So on cross-examination by lawyers for one of the people that you love in this courtroom, were you asked about your conditions prior to signing the plea agreement that you signed on December 28th, 2022?
Could you repeat that?
Yes. On cross-examination last week, do you recall being asked about conditions you endured before signing the plea agreement that you signed on December 28th, 2022?
Yes,
Do you recall being asked if you felt pressure to sign that plea agreement?
yes, I think so.
Do you recall being asked whether you felt intimidated to sign that plea agreement?
I don't recall that one.
I'll ask you, were you intimidated by the state into signing that plea agreement?
Was I intimidated?
Were you intimidated?
I wouldn't say I was intimidated. I was basically like, I just feel like it was forced on me at the time. I wasn't intimidated by it.
It was forced on you. We're going to come back to that word force, okay?
Yeah.
Do you recall on direct examination when I was asking you questions, do you recall you first mentioning something about the fact that your mom, unfortunately had become ill. Do you remember that?
Yes.
Do you recall telling me not to speak on her?
I said I didn't want to talk about her.
Do you recall Mr. Steele asking you about her multiple times?
Yes.
Did you have any problem with him talking about her?
No, because me and my lawyer had discussed, don't even get frustrated about it.
So is your testimony that you didn't mind Mr. Steele talking about it because you had a conversation with your lawyer about that?
Yes, he just told me to stay focused, and
Okay.
even with you, he just say stay focused and answer the questions.
And tell the truth?
Yes.
All right. When you say you felt forced, would you please tell the jury who it was that forced you to sign, or who you felt forced you, if anyone in particular, to sign anything on December 28, 2022?
I say the state, because when I addressed it and tried to change situations, they wouldn't change them. So
And it's still your testimony, is it still your testimony that there were things that you wanted changed that you did not get changed? Is that still your testimony?
Objection asked and answered.
Overruled.
could you repeat it?
Is it still your testimony that there were things you wanted changed in this plea agreement that you did not get changed?
Judge. Your Honor, could I talk to my lawyer right fast?
You may.
Or no? I don't want to. Could I?
All right, let's just take a recess.
I'll do it for you, counsel.
Thank you.
Go ahead, Ms. Love.
Thank you. Mr. Sledge, have you had enough time to speak with your attorney?
Yes.
During the time that you spoke with your attorney, is your attorney the only person that you spoke with?
Yes.
All right. Did you speak with any member of the state this weekend?
This weekend?
Yes.
No.
Did you have an opportunity to speak with your attorney this weekend?
Ma'am didn't talk, but
Okay. All right. So did you testify on cross-examination last week that there were portions of the plea agreement that you signed that you asked the state to change, but that the state refused to change?
no, what I said, yes, but they changed certain things, but it still was things that I had problem with. From my awareness, once if you call me to the stand, that I would be able to explain the things that they didn't change.
Do you recall when I first asked you questions on direct about the April 2015 drive-by shooting that you,
April 15.
the April 28th, 2015 drive-by shooting? Do you recall when I asked you about that on direct?
Yes.
Do you recall you told me you did that in your best interest?
Could you repeat that? You lost me right now.
Do you remember saying that was in my best interest when I asked you if you pled guilty to the shooting on April 28, 2015?
Yes.
And do you remember saying that I did that because it was in my best interest multiple times? Do you remember saying that?
You said that I took the plea in my best interest?
My question is, do you remember?
I don't recall. Mm.
Mr. Sledge,
Okay.
do you remember us talking about your 2015, April 28, 2015 shooting and that subsequent plea last week? You and me, not anybody else, while you've been on the stand.
You said the 28th drive-by shoot?
Yes, sir.
Yes.
All right. And do you remember I asked you whether you pled guilty to that? Do you remember that?
Yes.
And do you remember you told the jury, do you remember telling the jury, well, I did it in my best interest? And
Yes.
this is not a trick question, I promise you.
Yes.
All right. And do you remember you said that more than once? I did that in my best interest.
Yeah, I remember that part.
Okay. And when you say in your best interest, are you familiar with what is known as an Alford plea?
No, I don't really know what an Alford plea really mean. I just was saying that I pleaded guilty in my best interest.
And when you say that you pleaded guilty in your best interest, what do you understand that to mean as opposed to just flat out pleading guilty?
Could you repeat it?
I can.
Cause that was kind of tricky.
Okay. So if you enter just a regular old guilty plea and someone asks you, did you plead guilty? Would it be unusual for you to just say yes? I pled guilty?
Anything I plead guilty to, I feel like it's in my best interest to plead guilty to.
That plea that you entered in 2017, there was a special designation to it though, right? It was an Alford plea, wasn't it?
I didn't know it was an alpha plea.
When you entered the plea that you entered on December the 28th, 2022, did you recognize the prosecutor asking you questions as the same one talking to you here right now, me?
Yes.
All right. And did you recognize the prosecutor at the table with me as the same one I have my left hand on now, Ms. Hilton?
She wasn't in the courtroom when you did the plea. She went somewhere.
Okay. All right. So if we see the video, but we see Ms. Hilton's lovely face, you'll recognize Ms. Hilton as having been in the courtroom?
I don't remember seeing me here too.
That's fair enough. Do you remember seeing a judge who looked a little different than the one on the stand now?
Yes.
Okay. Do you remember seeing your attorney, Mr. Wright, there sitting with you?
Yes.
Right. Is that the same attorney that you had in 2015?
I don't think I got arrested in 2015, but if I would have, he would have been the one to do the case.
Did you testify on direct examination that Mr. Wright has been your attorney for 15 years?
Yes,
Could you tell the jury when Mr. Wright first started representing you in criminal matters?
I want to say like 08, 09, something like that, if I'm not mistaken.
Did you tell the jury on cross-examination that Mr. Wright is someone that you trust?
Yes,
Did you tell the jury on cross-examination that Mr. Wright is someone whose advice and counsel you take seriously?
I don't remember saying it like that. You put it in that word.
Would you just tell the jury right now then, how it is you feel about the lawyer who's represented you for the last 15 years?
He been great. Oh,
Overruled.
he
Go
been
ahead.
he been great to me.
Okay. And he was in the room with you when you entered the plea on December 28, 2022?
Yes,
Is this the first time you've had to testify at a criminal trial?
I don't understand what you're saying.
Do you understand that you are now in a witness box testifying in a criminal trial under oath?
This is my first time knowing that I was a witness to testify up on the oath.
All right. So this is the first time that you've testified in a criminal trial. Is that fair to say?
I ain't gonna say it's probably not my first time, but me knowing that I was gonna be called as a witness, yeah, this is my first time.
All right. Do you remember being asked on cross-examination by either Mr. Sharp or Mr. Steele? I believe it was Mr. Sharp, your friend Shannon's lawyer, whether you...
Overruled. I think she's just trying to get clear who it is. But we don't need the commentary.
Yes, Your Honor. Do you know who represents your friend Shannon?
Yes, I've been sitting in the courtroom like everyone else.
Which person do you recognize as representing defendant Stillwell?
Mr. Short.
All right. So do you remember Mr. Sharp asking you if on December 28, 2022, you found yourself between a rock and a hard place?
Yes.
All right. And what did you answer to him regarding December 28, 2022?
What did I say?
Yeah, what was your answer to that
I
question?
said yes.
And would you tell the jury what the rock was and what the hard place was?
The rock was the situation I was in, and the hard place my mother was sick,
And when you say the situation you were in?
incarcerated.
Okay.
And
All right. And hopefully, is your mom doing,
no, she deceased.
I'm sorry. So did your being in Fulton County Jail have any bearing on your decision to enter that plea that you entered on December 28, 2022?
Being in Fulton County Jail and away from my mother.
All right. Which one had the biggest bearing?
Being away from my mother.
All right. So being in Fulton County Jail wasn't a big factor in your entering that plea?
Objection, mischaracterizes his
I'm asking a
testimony.
question.
I couldn't hear them both at the same time, so.
I'll rephrase.
All right, she's gonna rephrase.
Mr. Sledge, was being confined in the Fulton County Jail a large factor in your deciding to enter a guilty plea on December 28, 2022?
Yes, it was, but my mother was bigger.
Okay. All right. Is there any reason why during the plea colloquy that the jury heard on Friday, that was played, or Monday, last Friday actually, that was played at the end of the state's direct, is there any reason, or rather, let me ask you, did you ever hold up your hand and tell the court you wanted to make some clarifications?
No, I would have directed it to my lawyer, and whatever you did, but what I wanted, you wouldn't do. You didn't do everything I wanted, which I state.
You were asked by Mr. Steele, your friend, Mr. Williams' attorney, whether or not the state ever sat down and met with you. Do you remember being asked whether the state ever sat down before the June meeting and before you entered that plea agreement and met with you? Do you remember him asking you that?
Yes,
Did the state ever sit down and meet with you?
no,
Did you ever agree to sit down and meet with the state?
I can't agree if the state don't come to me and ask me.
Do you, or has your attorney, or do you have any understanding that the state can't come to you except through your attorney?
No, I didn't know that.
Okay. Did you ever have an understanding that the state wanted to talk to you before you signed the plea agreement on December 28, 2022?
No,
Okay. Did you ever ask your attorney for an opportunity to speak with the state?
no, I ain't never asked them to speak to the state.
Why not?
I don't know. I can't tell you that else. I never asked him to speak with you because that's his job. That ain't my job. That's why I hired him.
Was there anything about the state that made you feel you couldn't speak with the state if you wanted to?
No, but if they would have came to me and asked me to speak with them, with that plea agreement was on there, I would have told them the same thing I told him when I took it, like, that ain't right.
Now, when we speak about the state, is your understanding that that means only the district attorney's office? Or do you consider the state the police as well?
I just thought all y'all work together. I don't know. They put you in jail, you put you in jail if you have to. So I don't know. Y'all both doing y'all job, I guess.
And so when police spoke with you back in 2015, did you consider them the state as well?
I don't know. I don't know. I think y'all work in two different departments.
You're right.
Because I don't see the state on the street locking people up. The police, I do.
Okay. So when you spoke with the police back in 2015, did you tell the police any of those things that you told your friend, Defendant Williams' attorney, and your friend, Defendant Stillwell's attorney, when they asked you questions on cross? Did you tell the police any of that stuff?
I don't think they asked me nothing like that.
You
I don't
think
recall.
that-
I don't recall them asking me nothing like that. You said the police?
Yes, sir.
I don't recall them asking me nothing like that. What Mr. Steele asked me.
Do you recall Mr. Steele asking you about that drive-by shooting?
Oh yes.
Do you recall the police asking you about that drive-by shooting?
Yes.
How much information did you give the police about that drive-by shooting?
I told the police it wasn't true.
Okay. Now, okay, so, and when I asked you on direct examination about that drive-by shooting, what did you tell me about that drive-by shooting?
I don't recall. You can refresh my memory.
Do you recall me asking you what you did before that shooting?
I don't recall it though.
Do you recall me asking you how did that shooting happen? Yes. I can show you. I can
Go ahead.
respond.
Overruled.
Thank you, Judge. Do you recall me asking you what led to that shooting?
I don't recall.
Do you recall telling me on the stand, or actually telling the jury, because it's not me. Do you recall telling the jury when I asked you on direct that you just went to pick up Mr. Garlington from the club, or that Mr. Garlington had gotten jumped on?
I think I told you I went back and got him from the club. That's what I told you.
And do you recall telling the jury when I asked you questions that you didn't see anybody who jumped on Mr. Garlington?
I told you I didn't know anyone that jumped on Mr. Garlington. The same thing I told them on cross. I didn't know exactly who it was that jumped on him.
Did you tell the jury on direct with questioning by me that you didn't see the faces of anyone who jumped on Mr. Garlington?
Yes.
And did you tell the jury that you didn't see the faces of anyone that you may have interacted with during that time?
Yes, sir.
Objection 403, wasting time, repeating, and misleading. Two different things.
Yeah. May I
Yes.
respond?
Yes.
Your Honor, Mr. Steele cross-examined the witness on this very topic. I believe that it is necessary to orient the witness to the questions I asked before I get into the questions that I want to ask him about what he told Mr. Steele, number one. So it's not a 403 waste of time in any way. And I believe that he made a second objection I'd like to respond to, but I can't remember what it was. It was kind of long. And leading, Your Honor, suggests an answer, and it does not consist of questions that simply require a yes or no response.
Overruled. And I'll give you a little leeway, but go ahead and get to what you actually want to get to.
Do you recall telling the jury when I asked you about the drive-by shooting that you never saw a shooting?
I don't recall.
Do you recall telling the jury when I asked you about the drive-by shooting that you just dropped off Demekion and Quindarius and you went on your merry way?
I don't think I said I went on my merry way.
You
but
didn't
I-
use merry, that's my words.
Okay, but I remember
just
exactly
went
what you
on.
said. I ain't saying I went on and directly left the scene, but I didn't actually witness them shooting the gun. That's what I said.
Is it your testimony today that on direct examination, you did not tell the jury that you dropped off Quindarius Zachary and Demekion Garlington and left and don't know what they did after you left?
I don't recall that.
Do you recall me asking you about another house getting shot up on Drew Drive after the house on Adele getting shot up?
I don't know in what article. I don't know the addresses.
Do you recall me asking you about whether you saw or participated in any other house getting shot up other than the house off MLK on Adele Drive? Do you recall me asking you that?
I don't recall.
So do you not recall as well telling me that you didn't see any house get shot up?
I don't recall me telling you that I seen the house get shot. I don't recall.
Now, what I just heard you say is, I don't recall me.
Me telling you that.
You don't recall you telling me what, sir?
I just don't recall, Ms. Love. I don't recall.
What is it that you don't recall? I'm sorry, I need the jury to know.
I don't recall.
What don't you recall?
I don't recall. I don't recall. You've been pressuring me so much, it's like, I don't even be remembering a lot of stuff you saying.
Is it that you don't recall telling the jury you did not see any houses getting shot up on April 28, 2015?
I don't recall.
Okay, today, do you recall seeing any houses getting shot up on April 28, 2015?
I didn't, what I'm saying, I didn't see, I'm not saying that I didn't know no shooting was gonna happen, but what I'm saying is I didn't like personally witness the house that you saying that Quindary, Zachary, and Garnington shot up. I didn't witness that.
I appreciate that clarification. That's not my question. I'm asking you today to tell this jury whether you recall today seeing any houses, since it's me talking to you, whether you recall any houses getting shot up. Do you recall seeing any houses getting shot up on April 28, 2015? No.
Overruled. So he just told you about the one house. So are you asking about any others?
Yes,
All
I
right,
am.
so ask it that way.
Yeah, you gotta tell me directly what house you talking about, cause when he cross-examined me.
No, that's not what she's asking. She's
Oh, okay.
asking any other houses besides that one.
Well, I didn't know I don't know the people that was shooting at the other house.
Okay. All right. Did you see any houses getting shot up? Forget the address. I don't really care what address. Did you see any houses getting shot up on April 28th?
I just don't think that's an appropriate question.
Okay, well, that's not for you to decide. So
Okay,
unless
but
there's an
I'm
objection
saying,
that's sustained, you go ahead and answer the question.
Yes,
You did see some houses getting shot up?
not houses. Now you putting more than one. It was one house that I probably seen.
Okay. Tell the jury what house you probably seen get shot up April 28, 2015.
I think it was Lexi. I don't even think it was a house. It was an apartment, if
Tell the
I'm not
jury-
mistaken.
Tell the jury what apartment you saw.
I don't know the name of the apartment.
What can you tell the jury about the apartment?
Where I was dropping Quindary, Miss Zachary off at. That's the one I could tell you about.
So, on Friday, when you talked about dropping off Demekion and Quindarius, weren't you dropping them? Were you dropping them off at the house off MLK on Adele Drive, or was there a different address you were dropping them off at?
I was drunk, Ms. Love. I don't remember which one it was.
Did your memory come back while you were being asked the same question by Mr. Steele?
No.
Do you remember telling Mr. Steele a whole bunch of stuff about?
I don't think Mr. Steele was the one cross-examining me on that.
Who do you believe was cross-examining you?
I think it was Mr. Short, not Mr. Steele.
Okay. Let's go with that for a moment. Do you remember telling Mr. Short then details about houses that you saw getting shot up on April 28, 2015?
I didn't go here.
Your Honor, I object. I object
Okay, well, can't object to the objection.
to the speaking portion.
Okay. All right, so I think she's asked him, if you need to approach, let's approach.
I don't mind either way.
Your Honor, the court
Let me
heard.
look at,
What is the court?
come on.
Yeah.
All right, let's get the witness back in.
Thank you, Judge. Mr. Sledge, please tell the jury what you remember today, everything you remember happening with respect to April 28th, 2015, from the time you picked up Mr. Garlington.
Love, I've been here 4 days, just found out how many hours. I can't remember all that stuff, so I don't recall.
She's not asking you now what you remember testifying to. She's just asking you what you remember about that night.
I don't recall.
When did your memory about it leave you?
I can't answer that question for you, but
I'm sorry?
I can't answer that question. I don't know.
Did you remember it when you were asked questions by Mr. Sharp? Mr. Sledge, please answer the question.
I don't recall.
You do not recall whether you remembered April 28th when you were asked question by Mr. Sharp?
I don't recall.
All right. When you were entering the plea agreement that you entered on December 28th, 2022, did you ever stop and ask the judge or tell the judge you wanted to clarify anything?
No, because I thought my lawyer had already did that.
And when you heard the state read out factual acknowledgments and ask you if they were true and correct, did you ever indicate part of them are true, but part of them are not?
I didn't think I could speak that in court.
Why did you think you could not speak it in court?
Because I ain't thinking like I could just burst out and say that while the judge reading, or while you was reading out, because the judge didn't read it out. I ain't think I can do that. That was never explained to me.
Between December 28th, 2022 and last week, did someone tell you you could burst out while the state was reading something?
No.
Interrupt?
No.
So last week when I was asking you questions and you told the judge I gave you a headache and made your blood pressure go up, you felt comfortable enough? Did you feel comfortable enough to do that?
Because I'm on the stand trying to explain. When you sit back there, you ain't explaining, but when you sitting on this side, you call me here to tell my truth and my understanding. And that's what I'm giving you. I can't give you nothing else. I'm only giving you my truth.
Okay. And so when you were sitting at the table next to your lawyer, did you feel more or less comfortable about giving your truth?
I don't recall.
Do you want to answer the question?
I just answered.
No, I'm asking you, do you want to answer?
I want to answer any question that you got for me, but if I don't remember, I don't remember.
And so what is it that you don't recall about being at the table with your lawyer?
I just don't recall, my love. I ain't trying to give you a hard time. But it looked like you trying to give me a hard time.
Mr. Sledge, would you tell the jury as between when you were in court on December 28th, 2022, and when you have been in court for the last 4 days, if there is anything different about parties in the courtroom that you can point out?
No.
So everyone here in the courtroom was in the courtroom with you on December 28th, 2022.
When you say
Objection, relevance.
Your Honor, it goes to changes.
Okay, overruled.
could you repeat it?
Were each of the people now in the courtroom today were,
Hang on. Yes. All right, so for the record, that objection is overruled. Let's get the witness back. Octavia. All right, go ahead, Ms. Love.
Thank you. Just 1 second. Mr. Sledge, would you please tell the jury who is in the courtroom with you today that was not in the courtroom with you on December 28, 2022?
Could you repeat it?
Can you rephrase that? Because that's going to be a whole lot of people. Just get to the point that you want to ask.
Yes. You already said I was here. Was there a court reporter here in the courtroom? Not this one, but a court reporter?
I think so.
Were there deputies?
I think so.
Were there DA investigators?
I think, yes,
Obviously, you said your lawyer was here.
yes.
All right. Was your friend Shannon here?
If you're trying to get to the point.
Mr. Sledge, I'm not trying to get to anything, and I really do need you to just answer the question.
Listen.
So if you could
But
please, Your Honor, if the
If you
court
could
would
be allowed to
instruct the
answer
witness
question,
to
Your Honor.
answer the question,
Listen to the question and answer the question.
And then
that's
you can
asked, And
explain.
then you may explain it.
I would ask
Thank
that he
you.
be allowed to complete his answer.
and Your Honor, since his answer was not responsive,
His answer was not responsive.
I'd ask that you.
Re-ask the question.
Was your friend, Mr. Stillwell, here in court with you on December 28, 2022?
No,
Was your friend, Defendant Williams, here in court with you on December 28, 2022?
no,
Was your friend, Defendant Kendrick, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Williams, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Stillwell, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Kendrick, here in
Objection.
court with you on December? The
I'm
objection.
saying,
I'll
why
wait.
you
Hold on,
raising?
Mr.
Hang on.
Relevance to whether I was in attendance at the time he took his plea.
Your Honor,
Overruled.
was the lawyer for your friend, Mr. Kendrick, here in court with you on December 28,
But
2022? You can answer first and I will let you explain, but I need you to answer
no,
yes or no.
but could you stop yelling at me like I'm your child or something? I'm not your child.
You are not.
You talking aggressive to me. You don't intimidate me. All them guys over here. So if you would have came to me and asked me that, I'd have told you the same thing. What if they was in my face or not in my face? I'm not scared of them or you.
I don't want you to be.
Well, that's what you acting like it. That's what you
Okay.
acting like you're trying to
So
paint.
do you want me to bring my voice down? And I
Yeah,
apologize if
don't
it
holler at
sounds
me.
like
I
I'm
ain't your
yelling.
child. Could I take a break? Y'all in the car.
No, we've had so many breaks this
Yeah,
morning. We
'cause
really need to get
I'm-
through this.
All right. So, Mr. Sledge, was either Quay that is in the courtroom here today in the courtroom with you on December 28, 2022?
No,
Was Lil Rod in the courtroom with you on December 28, 2022?
get to your point. No,
That is my point.
your point is
Okay.
pointless.
Was the lawyer for Mr. Huey Quay in court with you on December 28, 2022?
No,
Was the lawyer for Quamarius Nichols in court with you on December 28, 2022?
no,
Was the lawyer for Little Rod in court with you on December 28, 2022?
I don't know if that's been asked and answered or not.
It was not.
Okay, well, go ahead if you say it was.
Was the lawyer for
No.
Little Rod?
No.
On cross-examination, defendant Stillwell's attorney, Mr. Sharp, asked you about Shell, Kel, and Antrevia. Do you remember that?
I don't recall.
All right. When did you lose recollection of what happened 3 days ago?
I don't recall.
Are all of your answers to every question I ask from now on going to be, I don't recall?
Yes,
Why?
because I don't recall.
And what caused you to lose your memory?
You put so much pressure on my brain, I don't forgot everything. I can't remember all this stuff that been asked to me for the last 4 days. It's like, it's confusing. So I'm not, like you said, I completed the 9th grade. I'm not that intelligent to be remembering all this stuff that you keep asking me. My brain just everywhere. I might need to go see somebody after this court time.
Mr. Sledge, did you have any problem at all understanding the questions asked to you about Brian Steele?
I don't recall.
Right. Did you lose your memory at any point with Mr. Steele?
He wasn't pressuring me like you. He was helping me. He was explaining to me, he was breaking down, but it seemed like
I appreciate what you're saying. I'm gonna respond to that.
Objection.
Mr.
The witness should be allowed to answer the question.
Were you finished with your answer?
no, she cut me off.
Go ahead.
Go ahead, please.
I said, Mr. Steele was explaining to me, he wasn't pressuring me, but every time it seems like I'm getting up and with you, I'm giving you my truth and you still trying to pressure me to say something you want me to say when I'm giving you the truth that I know.
Mr. Sledge, do you understand that there's a difference between the way that a
I don't-
prosecutor can ask you questions and the way that a defense attorney can ask you questions?
No,
Do you understand that I cannot lead you when I'm asking you questions?
it's,
Sustained.
When you say that there's a difference between the way that Mr. Steele asks you questions and the way that I ask you questions, would you help me understand what that difference is so that I can ask you questions in a way that does not frustrate you?
Oh, well, I mean, he kind of has told you.
she ain't said it. She said, you overruled.
Ask your next question.
Okay.
Yeah,
All right. So will you help me break things down a little bit so that I'm not frustrating you? Okay.
you already have.
I understand.
I
Can
don't
we,
even,
can we rewind?
no.
All right. When you were asked about Antrevia, was Shell Kell the person you said who had also started a relationship with Antrevia after you?
I don't recall.
What is confrontational about that question?
I just don't recall.
Why don't you recall?
Because you pressured me, I don't recall. You heard my brain.
All right, so let's take an early lunch and you can calm down in the meantime, hopefully, and then we will come back. Let's see, it's almost 11:15. Let's come back at 12:30.
Yes, Your Honor, thank you.
I said 12:30, and we're a little after that because of the work on the sound thing, but that's gonna take way too long, so we're gonna have to have them do that after court today. Who briefly? Yes.
Thank you, Your Honor. Mr. Sledge, did you have a good lunch?
Yes,
All right, good deal. All right. And is your head feeling a little bit better?
a lot better.
All right, good deal. Mr. Sledge, I want to just, and Judge, if I broach an area that the court has told me to move from, I'll quickly move from it. Mr. Sledge, are you able to tell me what you remember about April 28th, 2015? What happened on that date? Everything you can remember today.
Do you want him to tell you about the entire day? You don't, do you?
I don't. And so the judge is helping me out a little bit. So starting from the point where you learned about Mr. Garlington getting jumped at the club, will you tell the jury, not the judge, the jury, everything you remember about it? Is that all right?
Yeah, I guess.
Okay, thank you.
From my understanding, like he got jumped on in the club, then I left the club, he called me back. We went and picked up gun. I want to say Zachary, and then we went, I don't know the name of the apartments.
Okay.
And then I want to say we traveled back down, traveled back around, if that.
I didn't hear you.
I said once we went to the apartments and then we went back to the house. I think that's what I said.
Take your time, and you do not have to, I'm not trying to get you to match up anything.
I
Okay.
asked her like, it been long 4 days, Miss Love. So
It's okay. Take your time.
if you have anything you can refresh my memory. But right now, I don't recall.
All right.
Try my best.
And that's all I'll ask, okay?
Yes.
All right. So I'm not going to try and trip you up. I just wanted whatever you remember today in terms of it.
All right, go ahead and ask the next question.
Okay. All right. Do you remember whether you went to the house first or to the apartment first?
I don't remember. I can't exactly tell you, but I don't recall exactly how I think.
Okay. And the house that we're talking about, is that the one off near MLK, off Adele?
I want to say that's the only house I remember going to. I
Okay.
don't remember.
And where were the apartments that you remember going to?
I don't remember exactly what it was. I just know they was in a gated area. It had a gate when you got to go through the gate. That's all I remember.
Do you remember whose they were, whose apartments they were? Like, why were y'all going there?
I think I was supposed to been dropping Zachary off.
Okay. Did his girlfriend live there?
I don't think she stayed there, but she was there.
All right. Now, was there any shootings that went on there? Did you see somebody else shooting or anything happening there?
Yes, I think that's what it was. They was shooting when we pulled up.
Okay. Now, I know you don't get scared easily, but did you consider that sort of a startling sight to see somebody shooting at the apartment?
For me, it was normal, so I can't speak for no one else, but
Fair
from
enough.
my perspective, it was normal.
All right. And were they shooting at apartments that you were sending or taking Mr. Zachary to?
I don't know if it was the exact apartment, but it was right there in that area.
All right. Now, in terms of shooting, how could you tell the jury, because they weren't there? Do you see guns pointing out a window or just like fire flashes? What is it that let you
I
know?
just seen the fire flash in front of the
Okay.
car.
Okay. And were you right up on the car, or were you like coming in the gate and you saw fire flashes from like across?
I
the
pulled
courtroom?
directly in front of the car and then I backed back.
Okay. When you pulled directly in front of it, had the shooting begun already?
No, they was doing it.
Okay. Did you realize they were doing it when you pulled directly in front of it?
No, it's like when we got there, then it started happening.
Okay. Okay, so for people who aren't you, that might have been considered a little scary. So what did you do when you heard the shooting behind you going on?
I backed out.
Okay. Did you back out and like quickly leave?
No, I got back to safety.
Okay. And where were Mr. Garlington and Mr. Zachary when you did that? Did they run inside, stay with you?
No, they got out the car.
All right. And did you see what happened? with them?
No, I was around the building, so I didn't really get out the car to see what was going on, but I backed up behind the building.
Okay. Did you have to pull around the car to get in front of it? Or did you?
No,
or
it's
did
a
they pull
straight
up
shot. It's just a straight shot through the apartments.
Okay, so is it fair? Did the car pull up behind you then?
What you mean?
Did I understand you to say that you ended up in front of the car that was shooting?
That mean they was probably back then facing like coming out and I'm coming in.
I gotcha. Okay. Did you notice what kind of car it was?
No,
Right. And did you have a belief as to who it was that was in that car?
I didn't know who it was.
Okay. Did you later form a belief as to who it was that was in that car?
No, I don't recall.
All right. Did you all do anything based on who y'all believe might have been in the car?
I already answered that question. I
Did-
answered that question 2 days ago when I told you about it.
Okay. Forgive me, I had a long weekend. Could you tell me what you all did based on what you all believed or who you all believe was in that car? There's nothing more that'll happen as a result of it, I promise.
I don't know who was in the car. At the time, I didn't know who was in the car. I still don't know if that was true, what was told to me, so.
All right. And that was told to you by Mr. Zachary or somebody else?
Well, it was told by other people too, so.
Okay. Other people that were there with you
In the
car?
street, in the streets, like when things happen, they be talked about in the streets.
Okay. Did you all react immediately or did it take a few days or something different?
I don't know. I couldn't really tell you because I told you I was behind a building, so I couldn't actually see what was going on.
All right. Okay. At any point, did you think that If Gang was involved in that?
I don't know because I told you from the night that he got jumped on, I didn't even see who jumped on him.
Right.
So I don't know. I don't recall. I can't say that.
Okay, that's fair. I'm not asking you if they were. I'm just. Judge, may I be allowed to ask the question?
Yep.
Thank you. I'm just asking you at any point if you believe they were, not whether you know, not whether they were, just at any point did you?
No,
believe?
I never believe. I never believe.
All right. Now, we talked last week about Antrevia Smith, and you talked a little bit about that on cross-examination, your relationship with Miss Smith. The Kelvin Watts who started dating Miss Smith after you did, was that the same Kelvin Watts that had a beef with Kenneth Copeland?
I don't really know if him and Kenny Copeland had a beef or not.
Okay. So did you ever learn or did you ever discuss any kind of beef that Kenneth Copeland had with Kelvin Watts?
I don't recall if we ever discussed Miss Love. I don't recall.
Okay. But is it fair to say that, let me ask you a better question so I'm not leading. Is the Kelvin Watts that started dating Miss Smith after you did, was he also called Shell Kale?
Yes.
All right, thank you. And do you know if Shell Kale, did you consider him having any family relationship to Donovan Thomas Jr.?
I never knew they was, how long I've been knowing Donovan Thomas, I never knew they had any relationship.
All right. How long did you say you knew Shell Kale? If you said it already, forgive me.
I don't know. He went outside when I was outside. He probably came outside. I started hearing about his name 2015. Before then, I never knew him.
Okay. When you say came outside, help me and the jury know what you mean.
Whenever he started hanging outside, I ain't know him before then.
So based on that answer, did he start hanging outside around 2015?
I don't know, Ms. Love. I'm saying that's when I started hearing his name in the street. Other than that, I don't know him.
All right. When you heard his name in the street, did you hear his name associated with Ifgane, sir?
No, not when I first started hearing his name.
At any point later on, did you hear his name associated with Ifgane?
Yeah, maybe, yeah.
All right. Now, do you remember whether that was after 2015, like 2016, 17, or during about 2015?
I don't really recall because it was late. It probably was late in 2015, but
Thank
I don't
you,
know.
sir. All right. Now, you were shown some dates in a book by Mr. Williams' attorney. I'm going to approach with the court's permission and with your permission. Is that all right? All right. So, did you testify, or a better question is, did you participate in every performance in 2015 that the Travis Scott rodeo tour included?
No.
All right. And do you remember when Mr. Steele was up here reading these dates to you and you were saying, yeah, you see them on the page?
Yes.
All right. Now, would you tell the jury if these dates are dates that you were actually at the location indicated on this piece of paper?
Yeah, most of them.
Okay. Are you able, as we sit here now, to tell the jury, just you can point them out and then read them out after you do, the dates that you did go to?
Through all the dates. I know exactly what day that I left that tour.
Okay.
I don't know the exact date, but I know what state I was in.
Fair enough. So did the tour did not start until after January 10th, 2015. Is that right or wrong?
That might be right.
Okay. Do you know of any tour date on this tour that you were talking about with Travis Scott that started before February 28th, 2015?
I don't know the exact dates, at least I'm looking at the book.
Here. Do you know of anything before February 28th, 2015? Here, you can turn however you want to look at it.
No, the first date say February 28, 2015.
Okay.
Yes.
And to your memory, is that the very first day of this Travis Scott tour?
Yes, from my memory.
All right. Now, this tour, when we say Travis Scott tour, who was the headliner? Was Mr. Williams the main attraction, or was Mr. Scott or somebody else?
Mr. Scott was.
Okay. Now, was he a major performer? And you got to forgive me because I don't know Travis Scott, okay?
Come on.
I'm not lying. I don't. Was he a major performer? I'm older than you believe, and you're going to have to forgive me.
Come on.
I'm dead serious. No.
You know, don't be mad at me if I'm laughing at you.
I'm not mad at you.
You just listen what I'm telling you.
Okay.
I know a lot of people know he's a big major artist.
Okay. All right. And is he a rapper, a singer, a musician, or something
I
else?
don't really, I think he do like, is it like rock or something like that? I don't really know.
Okay, all right. So he's a big performer, and did you go on that very first tour date on Saturday, February 28th, 2015, that's listed on the book?
I just told you, yes.
Thank you. Were you head of security for Defendant Williams on that day?
I want to say, I don't recall if I was or not, was I head of security, but I did a lot of different things on that too.
All right. Okay. Thank you for that. Now was that in Santa Ana, California?
Yes, that's what the booklet says.
All right. And is that your independent recollection, apart from what the book says?
I don't really remember. I could just go by the booklet and know the actual day and what state it was in.
Okay. And so does looking at the booklet make you remember, or are you just relying on the booklet to be right?
I knew the booklet was right. I had one myself.
Okay.
In that time.
All right. Do you remember who else within YSL went on this tour?
It was a lot of us. I don't recall everybody who was there.
Was it? I'm sorry.
It was multiples, so I don't recall everybody who was there.
Was that the first time you had gone to Santa Ana, California?
Maybe not, but
okay.
with a major upcoming artist it was.
Now, were you all with YSL, were you all like traveling with Mr. Scott, or were you all traveling separately? How did that work?
We traveled separate.
Okay.
Mr. Scott, not my friend.
Understood. When you got to the venue, wherever that was, did you all stay in the same location as Mr. Scott or separately?
I can't remember. They normally have different dress rooms, so I don't recall.
All right. And did you stay overnight, or did you all just perform and leave?
You perform and leave. Right. At least he had to be there more than one day, so I don't know. If his booklet says 2 days, sometimes we stay 2-3 days in the same state. So you might go to Dallas, you might go to Houston, you know, stuff like that. So.
And was Mr. Stillwell with y'all on this tour, February 28th, 2015?
I think so.
What about Mr. Kendrick?
I think so.
All right. Anybody else in this courtroom that would have been with y'all then?
Not I know of.
All right. Now, March 1st, that's listed here. Did you go on that one too?
March 1st? I was there every day except the day that I told you that, well, the state I remember that I went home.
Okay. So, are you able to say, just from memory, where or which ones you remember performances occurring at? I'll give you the book.
I can't remember all that. All right. I don't recall all that.
All right. On the days that are listed as travel days, are you able to tell the jury if you all actually traveled on those days, or were there some days that you all traveled on different days?
Probably actually that day, because you had to be in another state before he performed. It was a time limit, so like we had to stay on the time limit.
Okay. Are you able to tell this jury with 100% certainty whether or not Mr. Williams performed at every show reflected on this tour schedule?
I can't say that because I got sent home on a certain date. So I didn't finish the whole tour, so I can't say that.
Okay.
I didn't see him perform, but I could, like, until I got sent home, I seen him perform.
Without looking at the book, and I'm going to show you the book in a minute, but without looking at the book, are you able to say the date you went home?
I can't tell you the date. I remember what state it was.
Okay. Looking at the book, would that help you remember when you went home? And does that schedule just consist of that one page, or is there 2 pages?
It's 1 page. I remember right here.
Okay.
I got my finger pointed at it.
Okay, can you read out the
The date,
date?
it
and
was
the place?
Thursday, March 26, 2015.
Thank you. Are you able to tell the jury with 100% certainty whether on every tour day prior to Thursday, March 26, 2015, defendant Williams performed at every performance listed on this sheet of paper?
Not after that date, yeah, but that date, yes. That's the last show I was at.
What I'm asking is before you got sent home, before you went home, right?
Every show that he performed.
Every show day?
Yeah.
Okay. Do you recall who all was at the shows that he performed at every day before March 26, 2015?
No, I don't recall that.
After you got sent home, did you make any effort to follow what was going on as he toured?
No.
So when you got home, did you just kind of blank out and not listen to or anything?
I enjoyed myself with my family.
Okay. Did you speak with or talk to or communicate with defendant Williams or any other member of YSL who might have been touring with him?
No, because I was trying to get family time in, so I didn't call and see what Mr. Williams had going on. I was more focused on my kids.
When you got sent home, would you tell the jury how it was that you were sent home, like by bus, train, plane, car?
I don't even actually think he sent me home. I requested that I was ready to go home, but I went by plane.
Oh, okay. Did you, did that request have anything to do with your family? What happened?
No,
What?
I was just ready to get home and see my kids at the time.
Fair enough. Did anybody else leave at the same time you did on, was it March 26, 2015?
I don't recall who all left at certain time because everybody didn't leave and go the same way they kept on the plane.
Okay. Was defendant Stillwell still with Mr. Williams on this rodeo tour of Travis Scott's when you left? Do you remember?
I don't recall if Mr. Williams and Mr. Steele went home or he stayed on tour. I don't recall.
Do you have any memory about Mr. Kendrick and how long he stayed?
No, I believe Mr. Kendrick stayed the whole while. If I'm not mistaken, Mr. Kendrick was like a backup hype man or something at the time.
Was a backup hype man?
He was on stage with him performing.
Okay. Was Mr. Copeland with him? Do you know?
No, I don't remember Mr. Cole.
What about Mr. Zachary?
I think Mr. Zachary had got sick. He went home way before.
Was Mr. Stevens with him?
I don't recall.
What about Mr. Garlington? Was he with him?
I don't recall.
So without me going down a list of people you don't recall, can you tell the jury if there's anybody else you recall being on this tour of Travis Scott's with you and other YSL people?
No, I don't recall.
Okay. DK, Walter Murphy, was he at ever any point on this tour?
I don't recall.
All right. Do you recall ever being on tour with Mr. Murphy?
I think I was at one point in time, but I don't recall when he left. I don't recall that.
Okay.
I won't say that he was never on this tour.
Yes, sir.
But I don't recall when he left off the tour.
Okay. Now, is this tour that you're just pointing to, is that the only tour that you've accompanied defendant Williams on as either head of security or something else? Or is there any other tour that you can tell the jury that you worked or were a part of?
From my understanding, what I know, I only know about 2 tours. I don't forgot what the second tour name was, but I was there.
All right. Was that after or before the one?
It was after.
Do you remember how long after?
It probably 2019, I want to say.
Okay. And was it in the States or was it like in other countries or something different?
We went to Atlanta, but it was different states. And I think like on the tour, he did go to another country at one time.
Say it for me one more time, sir.
I think he did go out the country
Mhm.
on one of the dates. I just don't remember what date.
All right. Do you remember whether he was the headline by 2019?
Yes, he was headline.
Okay. And did he have other artists performing with him?
Yes, his artist.
All right. Besides people from YSL, like with this, he was performing with Travis Scott. Did he have some other people besides YSL performing
I
with him
don't
in
want to say
2019?
the guy. I don't remember the guy's name. It's Kelly, something like that. I think it's something like that. I don't want to use the term of what his race is, but his name Kelly or something like that.
Was he my race?
No,
Okay.
he was his race.
He was his race.
Yeah. Since you want me to
Alright.
say it.
You're all right. That's all right. All right. Was it Machine Gun Kelly?
That's who it is, Machine Gun Kelly.
Okay. All right.
I'm not familiar with all the rappers, but
Okay. But Mr. Williams was the top line and Machine Gun Kelly
Kelly
was
was, yes.
with him. Okay.
Yes.
All right. Now, am I reading correctly that this rodeo tour lasted February 28, 2015 to April 3rd, 2015?
That's what it said in the booklet, if that's what it is.
And you can look on other pages if you need
I don't
to.
think it's on the other page. I really look.
Okay.
But yeah, that's the ending date.
Okay. So is it your memory that after April 3rd, 2015, where it says travel home, there was no more rodeo tour?
No, there was no more rodeo too.
Okay. When you worked on the tour in 2019, do you have a rough estimation of how many places, how many cities y'all visited?
No, it was a lot.
Okay. And do you have any idea of who all within YSL would have accompanied you and Defendant Williams on that tour with Machine Gun Kelly?
I don't recall everybody who was with us, Miss Laura.
That's fair enough, Mr. Sledge. Do you recall anybody though?
Person I remember there, I know Mr. Kendrick was there.
Okay. What about Mr. Stillwell, 2019?
I don't even remember what Mr. Steele was. No,
Okay.
I don't think. Oh,
Just-
whoa, let me back up.
Yes or no? Don't
Let me
tell me.
Can I bag up? I don't even think Mr. Kendrick was there. I'm sorry for that.
Okay.
I don't think Mr. Kendrick was there.
Okay. Was Mr. Murphy there to your knowledge?
No, I don't recall.
All right. What about Mr. Zachary?
I don't recall.
And did you and Mr. Williams, y'all stay at the same hotel and things like that on that tour?
Yes, I was basically everywhere it went, probably like my room was like next to his, was probably up on the floor.
Okay. Now, when you talked about earlier knowing Mr. Williams' music, but you can't recall always songs, are you familiar about any YSL members that he talked about in his songs?
I don't recall. If you got anything to refresh my memory, you can.
All right. Do you have any memory of any songs that Mr. Williams referencing a woman getting robbed by a tick? I do so. I blank her and she get robbed by a tick.
I don't recall. That must was in the early time. I don't recall that song.
Okay. When you say in the early time,
I'm saying like in his beginning of his career, I don't recall that song though.
for you, can you tell the jury what you consider the beginning of the career, the earlier part that you wouldn't remember, just so they have a frame of reference?
Probably around, I guess around his early career. I can't give you exactly a year.
Okay. 2014.
Even if you tell me and you don't got it in front of me, I can't tell you.
All right. Okay. What about Lil Woody popping at your noggin? Does that sound familiar?
Yeah, I think that was on the song.
Do you remember what song that was on?
I want to say Halftime, if I'm not mistaken.
Any idea when Halftime dropped?
No, I don't remember exactly what year Halftime dropped either.
Okay. Do you remember around like 2014, 2015?
I don't remember that.
Okay. Were you working as head of security during that time?
I don't recall that because I don't know what year. I can't answer that for you because I don't know what year it came out.
Okay. In March 2015, you said you went home around March. What was March?
Whatever Phoenix, Arizona is.
Phoenix, Arizona.
After that show, I went home.
Okay. All right.
So it would have been the next day that I went home.
Okay. All right.
So I didn't travel to the next state with them.
All right. All right. So March 26, 2015 is Phoenix, Arizona. You would have gone home like March 27th, that Friday.
Yeah, that morning.
That morning? Okay. All right. Did you ever hear, sir, you want to see it again?
No.
All right. Did you ever hear, while you were there, before you went home on March 27th, did you ever hear Defendant Williams refer to any other artists in his music while he was on stage? Other than Travis Scott?
I don't recall because I don't recall all the songs he performed.
Okay. Did you ever hear him diss anybody on stage?
I don't recall.
And I'm going to have to say the word, but I hate to do it, but I'm going to ask. Did you ever hear him call anybody a bitch on stage?
I don't know. He probably said bitch in a lot of songs. I ain't gonna say like he called no one no bitch. I never heard him call nobody a bitch on stage.
Okay. And did you ever hear him refer to anybody substituting one part of their name for the word bitch?
No.
Okay. When we were talking about that video with you, Mr. Zachary, that last week, the video, I'm sorry, I'm switching gears. I'm switching gears.
Here, there.
But I ain't
That's
gonna
how
be
you.
aggressive.
But that's how you confuse me. You going to one subject and then you jumping all the way left field.
All right, I'm gonna try and orient you. Last week, when you and I were talking, do you remember me putting up a video of you and Mr. Zachary, and one or both of you had a gun, and you were saying something like, "We're not going back and forth," and you were talking about Kale in the video.
Right.
All right. When you were, do you remember when it was that you filmed that video? Not posted it, but filmed it.
I don't recall when we filmed it.
Okay. And when you were filming that video, do you remember saying that at any time that it wasn't about a girl?
I don't think we never even mentioned a girl name in the video. So.
Okay. So is it fair to say, or is your testimony that the stuff you said to Kale wasn't about no girl?
I don't recall. I can't say it. I don't recall. Cause you saying what I said. I don't recall because I ain't say nothing about no girl in the video.
That's fair. All right, but do you remember the video?
I remember we made the video, but I don't remember what I said in the video.
Ms. Nye, are you able to pull up that video? And what number was that? 441. All right. We're gonna play 441 for you one more time.
You little strip ass nigga. We ain't really going back to no nigga. You little bitch ass nigga. I know what we hit. I'm everywhere. Yeah, fuck you nigga, Kel. Whoever else, nigga. Well, nigga. Pop, 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 nigga. Whoa. They said they ain't really going back.
Okay. You're chuckling.
Cause
now,
it's funny now.
it's funny now.
Yeah, that video.
Now, who other than Kale were you talking to when you said and whoever else?
I just said whoever else.
All right. Now, what were you meaning to tell Kale?
I wasn't meant to tell him nothing.
Okay.
I said what I said in the video.
All right. Which was we're not going back.
I ain't going back and forth with him.
All right.
I ain't say them, I said him.
Right. Was he trying to go back and forth with you about something?
If you want to be honest, they were saying that he was looking for me about treatment. So
Okay.
that's the whole thing. So when he didn't respond to me when I DM'd him, I made sure he was gonna be able to see what I was saying.
What did you DM Kale?
I DM, I don't got no problem with him about no girl.
Okay. And when did to your knowledge, did Kale say something about Mr. Zachary?
I don't know. No, I can't recall if he said anything about Zach. I don't know.
Then I'm gonna have to fall to my country roots and ask you what was Mr. Zachary doing up in there with y'all?
I don't know. He was just being silly in the video too. It was all silly. It wasn't in that serious. Cause when I seen Kel, he ain't do nothing to me. And I ain't do nothing to him. So it wasn't that serious.
So for you, putting guns on the internet ain't that serious? Is that fair?
No one was shot. So I don't think it was that serious. The video.
Okay. All right.
You know, also walk around with guns all day. It ain't that serious.
All right. When you orienting you back to the rodeo tour, not trying to switch up and change you and confuse you.
That when you first screamed at. You went from here to there.
Yeah, I'm trying to get past it and go
And
fast.
I'm trying to stay focused with you, but you started throwing me off.
All right.
Come on.
When we're talking about the rodeo tour, you said you had to go home, but you were working. Did you have any kind of contractual obligations you had to fulfill before you went home?
He'll let me go home anytime I wanted to, no matter what the contract was. He'll let me go home. If I tell him I want to go home and see my son, he'll be like, he'll let me go home.
All right. And did you have someone to replace you when you went home?
Yes, I was head of security, so that means I only choose the security.
All right.
That don't mean I did security.
All right.
Head of security just means like I could come say, we're gonna get Miss Love, we're gonna get him, we're gonna get her, we're gonna get Mr. Wright. And if one of you don't do right, I just say, we'll give him a plane ticket.
Did you have responsibility for sending folks home to act it up on the tour?
No, I don't have responsibility to that.
Okay. Now, on cross-examination, going back to...
Israel.
Thank you. This is Defendant Williams number 255, right?
Yes.
All right. You told Mr. Steele that you had seen that, you recognized that before,
Yes.
right? Where had you seen that?
If I am mistaken, man, when it was posted and added, I want to say, man, Mr. Williams was together.
When it was posted and added, y'all were together?
When the guy added him, me and him was together.
Okay.
That's why I remember this post.
Are
And we
you-
were both like, I think he was gonna try to use it in a song or something, but he did. I don't know.
Okay. Are you familiar with D-Mac, Got Me Too Banging?
I don't know him personally. No, I don't know him.
Now, where was it that you saw it?
I want to say that was Twitter or something at the time, if I'm mistaken.
Now, are you tagged on this tweet too?
No, what are you getting at?
The jury doesn't know, so I'm just asking.
You showed that they presented it, and
All
they
right.
see I'm not tagged on them.
So when you say that you and Mr. Williams were together, were you looking at his
Who-
Twitter account?
Yeah, we were sitting there looking at the phone together.
At Mr. Williams' phone?
Yes.
All right. I'm going to pull up what I will mark for you as State's Exhibit number 4. Judge, I'm going to, for the purposes of this question, mark the clip that I'm going to show as State's Exhibit 447. I'm sorry, 449.
Okay.
And it is from 1:03:30 to 1:08:17 of Mr. Sledge's testimony on September 5th, 2024, when I asked about the video of Defendant Williams speaking into the camera, talking about they lied to their mama.
September 24th.
Last week,
Oh,
just last week.
I was gonna say,
Yeah. Just take a look at it, if you will.
I will.
Okay, thank you.
I'm not trying to give you no hard time.
Thank you for trying not to give me a hard time.
Take a look at it.
My apologies. Yes. Miss Knight, would you- Mr. Steele, do you mind coming over to Mr. Knight, Miss Knight, so so that she can show you what we're about to show?
Anybody else? Any of the other?
And anybody,
attorneys?
yes. And Judge, so that our record is very clear, it will be 449 Yankee.
Okay, thank you.
And thank you for not giving me a hard time.
I don't want to. I just want to get up, get out of here.
All right.
I don't want to give you no hard time.
Is it done? Judge, just so that the court's aware, we're making it available, but we're playing it through the transcript so that the volume isn't overheard by anybody else in the courtroom. And with the court's permission, I'm just going to sit while they're looking.
No, I'm good.
Mr. Steele specifically, I think there's one portion he wanted to add.
Okay. Mr. Steele, is that right? Did you want to
I
approach
don't have
about
any-
a particular section? I mean, did you, is there, do you want to?
I would like to because he asked for something specific that I would like.
Oh, okay. All right. Do y'all need a break at all? Okay.
Jesus.
Sledge, I'm going to put in front of you a portion of your testimony that we have and will mark as 449 Yankee, just for the purposes of the record. And I want you to listen to it. It will be approximately 2 minutes. And after you hear it, would you just tell me if you remember that? I don't want to ask you just straight out, do you remember something, okay?
Okay.
I don't mind, Judge. I'll tell him if you don't, if you give me a second. Hold on. Before you do anything, okay?
Okay.
Judge, that will be from time 103, 1:03:30 to 1:08:17. Yes, a little more than 2 minutes. I mean, yeah. I'm sorry. Me and my bad math. Can you hear anything? Can you hear anything? Can you hear?
I can't really hear it. It's real low. Hold on. Yeah, it's real low.
Because we can't hear what you hear. Can you hear it now?
You try to listen to it and see. Can't you understand what it's saying? Can't understand.
You're right.
I can read. I don't really understand. Be hard for me because I can read words and I don't be able to understand.
Okay. Try these right here.
Who had them? I don't want to just put anything in my ear.
Judge, may I get some
Sometimes. Oh, ain't that nigga? I don't want to put nothing in my ear that nobody else has. Yeah, do something different. No. But I don't want to use that though. Yeah, get something else, yeah. That's a perfect. You ain't finna, I don't want to wake up my ears broke out.
Right. So right.
You ain't gonna pay it in. You ain't gonna pay that doctor bill. Okay. Right. Me neither. So let's just do it the right way. Yeah.
You can pull them.
Oh, okay. Sure.
You tell me.
Oh,
It doesn't matter.
okay. I just want to make sure I can hear it.
You can?
Stop.
Get back on.
Okay. Did it stop?
I remember now.
You do remember?
But your memory is.
Hold
I
on.
just, okay,
We can't talk about that.
okay. You can get it if you want. It ain't there, but you can get it. I know what you're talking about.
You just, when it stops at 108. Right here.
You can stop it if you want.
Okay, 108, just listen to it through 108.
You stop.
108, 17.
I'll let you keep this, okay?
Yes.
Mr. Sledge, having heard what you said when I asked you about states 449 Yankee, do you recall my showing you the video of Defendant Williams looking into the camera, talking about they lied to their mama?
Yes.
All right. And do you recall me asking you whether that was your voice in the video?
I told you it sounded like my voice.
And do you recall me pressing you, asking you, was that you?
When you just showed me video, I see now, but that's why when I told you it sounded like me, I thought you just took it as that was me, because I told you it sounded like me, and the only way it can sound like me, I had to be there in the room.
Do you recall telling me that you did not remember being in the room?
I see on the video I did, but like I tell you, you were pressuring me so much that day too. My mind just was everywhere.
And when I asked you if that was you specifically who said snitching bitches,
I said, yes, that was me. That was my voice. Sounded like my voice. That's what I said.
did you ever acknowledge though that that was you in the video?
I said it sounded like my voice. So yes, I acknowledge that with me if I said it would sound like my voice. I ain't say it sounded like Miss Love, and I said it sounded like me, that record, that to me, that's saying it was me.
All right. Do you recall me asking you where you were?
I said, and I told you I didn't remember whose house it was, but I did. I said that sounded like my voice.
Do you recall me asking you who all was in the room?
I don't recall you asking me that. I ain't hear that on that neither.
Do you recall me asking you the names of anybody else that was there?
Not I recall you didn't ask me about nobody. You was on the Pacific asking me about my voice. That's what I remember.
And do you recall at some point telling me, I'm not saying that it's me, I'm just saying it sounds like me, so I can't tell you?
Yeah, I told you it sounded like my voice. That's all I remember telling you. It sounded like my voice. So I know if it sounded like my voice, I just thought you say, yeah, that's him. He said it sounded like your voice.
Do you remember Doug's attorney showing you the same video a day later?
Yes.
Do you remember him asking you, was that you in the video?
Yes.
Do you remember telling him, yes, that is you in the video?
Yes, because I had the day to think about it, and then I was like, yeah. When I was still planning in my mind when you showed it to me, and then I thought about it, I was like, yeah, that is me in the video saying it. It's my voice.
Is that the video that you were thinking of when you were talking to me back in June with your attorney, Lieutenant Lansico, and myself out in Fayette?
I don't even remember you asking me about that video, Ms. Love.
Do you remember me telling you on direct or asking you on direct about a video where I asked you if you had seen or did you know the video where they say you lie to your mama, you lie to your kids, and you said that wasn't me?
No, I remember telling you I didn't see me in the video. I seen Mr. William in the video, but I don't recall the statement you make.
Thank you. And do you recall me asking you then, where had you seen that video before we met in Fayette?
I don't recall, but I just heard it. Something about you asked me that. And I told you I seen it before time and I seen it recently.
Now, between the time I showed it to you and the time that Mr. Steele showed it to you, did you go look at it and listen to it again?
No.
All right. And so what happened that made your memory precise about not just the fact that it was you, but where exactly it was shot? I'll clear it up. Bad question. Do you remember telling Mr. Steele where that video was taken?
I don't recall Mr. Steele even asking me where it was taken. I don't even recall him asking me that.
Your
Do-
Honor, could I object at this point, 403?
Do-
Yeah, I'm not, I mean, we've all heard the testimony, so whether he remembers it or not at this point's not really the issue. Can you just ask the questions you intend to
Sure,
be
Your Honor.
asking?
Thank you. Mr. Sledge, why did you remember who all was in the room when the video was shot, when Mr. Steele asked you the question?
I just told you, when you asked me, I didn't remember. But when I left that day and I thought about the video, and then I realized everybody's voice who was in the video.
Okay. And what about the time or the date that the video was shot? What did you remember that too after you left?
He showed me the date of the video he had, and then I remember it was a repost, different date. I don't remember the date of the repost, but I knew where he cross-examined me on, I knew the answer to that question.
And do you remember me asking you about what what you understood Defendant Williams to be talking about when he said they lied to their mama, they lied to their sister and all that stuff? Do you remember me asking you about that?
No, I don't remember you asking me that.
At any point, having heard the video again today, did you hear anybody reference lying in the courtroom on that video?
Yes.
You heard somebody say something about lying in the courtroom?
Oh, no. You said lying in the courtroom?
Uh-huh.
I don't even know if I just heard that, Ms. Love, to be honest with you, but I think I did. I'm not mistaken. If you got anything, just show it to me.
Your Honor, state request permission to play against states 447 Yankee.
That's
The video
the-
itself.
Okay. All right.
And so even hearing it just now, you didn't remember, right?
No, if you show me again, like that part.
Okay, don't worry about the earphones. We're gonna put it up on the big screen.
Gotta look up.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters, they didn't get ready in the courtroom and tell the God that is true.
Fuck, nigga.
Don't get it. Y'all nigga need to get fucking killed, bro.
You snitching bitches.
From me and YSF.
I don't hear it say lying in the courtroom, though.
All right. So when you were asked on cross-examination by Mr. Steele, if that video talked about lying in the courtroom and you said, yeah, was that a mistake?
Yeah, that was a mistake. Cause
Okay.
I didn't say lie. It didn't say lie in the courtroom. The voice didn't say lie in the courtroom.
Okay. What did you understand it to be saying?
What he said or what in the video it said.
The video.
It's I'm lie on God.
And when Thug is talking, what is he talking about doing in the courtroom? Telling the God's honest truth?
Yes.
All right. And after Mr. Williams says, and you get in the courtroom and tell the God's honest truth, you need to get killed, bro. That's from me as YSL. Since you realize now that that is your voice, Would you tell the jury why you say snitch and bitch?
Because snitch is a liar to me.
Okay. Did you just not say that he said you get in the courtroom and tell the God's honest truth?
Well, I'm in the courtroom telling the God honest truth. So whatever he said, what he said.
Okay. So when he's talking about telling the God's honest truth in the courtroom, why do you follow that up with snitch and bitch?
I just said something. There wasn't no reason of following it up.
Do you consider a person who does get in the courtroom and tell God's honest truth on their friends snitching bitches?
No.
You were also asked on cross-examination by Mr. Steele about a meeting that you had with Lieutenant Lansco, your lawyer, and me out in Fayette County.
Yeah.
Call that?
Yes.
Did you let Mr. Steele know before we met that we were actually going to have the meeting?
Did I let Mr. Steele know?
Yep.
No, I hadn't talked to Mr. Steele before that.
All right. Did you let anyone at his office know that we were going to have that meeting?
No.
And afterwards, did you let him know that we had just had it?
Could you be more direct? What you trying to say?
Only what I'm asking.
You said, did I do what?
Did you let Mr. Steele know that we had just had that meeting?
When? After we had the meeting?
Yes, sir.
Yes, yes.
Okay. Did you ever let me know that you had that Zoom call with Mr. Steele?
No, I ain't. Because my lawyer put the Zoom call together. I didn't put it together.
Okay.
Mr. Steele didn't call my phone himself and say, Mr. Sledge, what's going on? No.
Okay.
My attorney was on the Zoom call.
Okay. And on the Zoom call, or rather last week, Mr. Steele asked you very pointedly, if you recall, do you remember Mr. Steele asking you, did Miss Love, or did you tell Miss Love that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
I said that to you and Mr. Steele.
Do you recall Mr. Steele
asking me that?
you
Yes,
that?
yes.
Do you recall Mr. Steele asking you, did Miss Love tell you, do not tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
I wouldn't say it was said like that.
Hold on a minute. Do you recall him asking you that?
Yes, yes.
And do you recall telling him, yes, Miss Love told me, do not tell the jury that Defendant Williams encouraged me to take Kenneth Copeland to the police station?
You didn't say it at the meeting June 9th. You didn't say it that way. But when I brought it to your attention that Mr. Williams told me to take me and Kenneth Copeland to the police station, your exact words to me, I don't want you to say that, and I would not be asking you that question.
So at what point did I tell you not to tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
You didn't use the word jury, but that's the way I took it, because from my understanding of this process, that I would be speaking to the jury to try to prove the facts to the jury, and I just thought I should come in and tell my truth.
When your lawyer and you, Lieutenant Lancico, and I sat outside that coffee shop, were you in any kind of handcuffs?
No.
Did you come on your own?
I came willingly with my lawyer.
Did you leave on your own with your lawyer?
Yes.
All right. And did anybody try to read you any kind of rights or anything like that?
No, you know that. I would have been in
But the
jail.
jury doesn't know that, okay?
Right.
So did you feel free to say whatever you wanted to say?
I just told you, I said what I said, free, yeah.
All right.
I'll freely say what I want to say.
Okay. So during that conversation, were you encouraged to come into the courtroom and simply tell the truth?
Yes,
Were you encouraged to simply tell the truth by me?
you said it out your mouth that you wanted me to come here and tell the truth, but you said it out your
Were
mouth.
you encouraged to tell the truth in front of Lieutenant Lancico and me by your attorney?
Yes,
As a matter of fact, did your attorney tell you to act as if any question the state asks you, they already know the answer? So don't try to finagle anything. Tell them the truth.
I don't recall him saying that into me.
I hate to use this, I'm not being blasphemous, but did your attorney tell you to pretend like the state is God and they know everything?
No, he didn't say that.
Okay,
I know that. You heard me.
all right. Do you,
Leave it alone. Come
do
on.
you remember me asking you
You're
about the
going too
video?
far, gang.
Do you remember me asking you about the video and you're denying being in a video where you
But-
say you lie to your kids?
I never denied the video. I said you don't see me in the video. They're my exact words. to
Right.
you. That ain't denying the video.
Okay. And do you remember after that I said, I've seen a video with you in it?
You said you seen the video with me, and I said you didn't see no video with me in it.
And do you remember me saying, yes, I have?
But
And you kind of smiled.
at the time, you were referring to video that Mr. William posted, not the video that I posted. Because if you would have said the video that you posted, Mr. Sledge, I would have said, yeah, that's me in that video.
Mr. Sledge, did I make reference to whose video it was? Or did I just ask you about
I
the
think
video?
you made, to me, I thought you, when you brought up the video with Jeffrey in it at first, then you brought up another, you brought the video up of Jeffrey. Because I told you that wasn't me, and I said you didn't see me in no video.
Okay, no problem. Now, on direct examination, do you remember as you sit here today, me asking you whether Mr. Williams encouraged you to take Kenneth Copeland to the police station?
In this courtroom?
In this courtroom.
Yeah, you asked me the question. I figured you asked me the question because my lawyer called me and asked me, what did you, Ms. Love, say to you and at me? So then when you told me at the meeting, you wasn't gonna ask me the question, but then you get in the courtroom and ask me the question.
So,
That's what happened.
okay. So was it that I said I'm not going to ask you that, or did I tell you not to tell the jury that?
You said how I took it. When
How you took it. I just
Okay.
need to know my words. John,
It's non-responsive. Ask your next question.
my words only. Did I ever tell you not to tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station? Did I ever tell you that?
You just said you didn't want me to say that.
Okay. Now, is it your testimony that I said, I don't want you to say that, or I'm not going to ask you that?
Both of them.
Overruled. We don't really have a clear answer.
All right. And it's your testimony that your lawyer and Lieutenant Lancico were still right there when I said these words that you heard?
Yes, so I
Okay.
wouldn't have said it.
All right. And based on what you just testified to the jury, you gleaned from that I didn't want you to tell the jury.
I never used the word tell the jury. I just said exactly what you said to me. I say, Ms. Love told me that she didn't want me to say that, and she wasn't gonna ask me that question.
Okay, so then your memory is not, you don't remember telling Mr. Steele. You do remember asking Mr. Steele saying, did Miss Love tell you do not tell the jury?
If he said jury, I forgot I made a mistake, and I should have corrected Mr. Steele if he said jury. but I'm telling you what you said to me in the meeting. I ain't saying you said don't tell it to the jury. But that's the way I took it too, cause that's who I'm supposed to be talking to, right? Telling the truth to, right?
Right.
Okay, so
Okay.
in my way, not the lawful way, that's the way I took it. Cause if somebody tell me, oh, I don't want you to tell my girlfriend this, I'm gonna take it this. You feel what I'm saying? You don't want me to tell the truth.
Okay. So, all right. We're going. So were you surprised when I asked you, did he encourage you to take Kenneth Copeland to the police station if you thought I didn't want you to tell the jury? I'm exploring what he said his understanding was.
Overruled.
So were you? When I asked you that question, were you surprised given that you thought I didn't want you to talk about it?
I don't know. I can't recall. I don't know.
All right. Now, on cross-examination, did you tell Mr. Shart that you didn't feel like you could go to trial, or you didn't have the ability to go to trial?
I said I couldn't afford to go to trial.
Okay.
That's the question he asked me. He didn't say the ability, he said afford.
All right. And that's the reason that you answered yes to all the questions that you answered yes to on State's Exhibit 444 Yankee and 1AS?
I don't recall.
Having had time to think about it now, do you remember and realize that your sentencing acknowledgments placed you in peril of probation revocation if you testified inconsistently with something you said was true during your plea agreement?
I don't think I testified nothing that wasn't true today, if I recall.
Do you remember testifying on last week when I asked you specifically about portions of what you agreed to, and for you to tell me if any part of it you're now testifying is false, to label it false, and if any part of it, if it's all true, to tell me it's true? Do you remember me having that conversation with you?
I remember the conversation, but you had put so much on, I don't even recall what went on.
Do you remember me putting in front of you State's Exhibit 447Y? And
Yes. You'd like a new question? Oh, okay. Right. Whether he remembers it or not is not really the relevant matter.
Oh, God.
all right. Did you testify that
I never seen
number?
that. Not
I
highlighted.
give you the number.
All right.
Did you testify that number? I took it already. I put it back. State's Exhibit At 1AS. Here it is, okay. The second part. Did you testify that, looking at this, at State's Exhibit 1AS, did you testify that number 3 under defendant's factual acknowledgments is not entirely true?
No, I didn't say it was not entirely true. I think I remember I said the part of the support of YSL, and you put Care as a robber gang member. I told you I didn't even know he was that gang at the time. And if I made a mistake anywhere else, I made a mistake.
All right, do you remember me putting, now I have to ask, do you remember, Your Honor? Do you remember me putting State's Exhibit 444Y in front of you?
I remember you putting all these papers in front of me, but I don't like.
Do you remember me asking you to go over each number, and if one of it is true or one of it?
Oh, no.
Do you remember me asking you that if all of the statement is true, to tell me and label it true, but that if any of it is not true, to call it false? Do you remember that?
I don't recall that, Ms. Love. Like I told you, you've been confusing me for so many days. You've been confusing me since I've been on this stand. So I don't know, like now, you jump from one thing to another thing. My brain don't move as fast as probably yours. I might don't learn as quick as you do. So I don't remember all this stuff. You putting all these papers in front of me ain't gonna make me remember.
Okay. All right.
So whatever you trying to get to.
All right. We're just getting to the questions. So we'll take it slow.
I don't remember.
All right. 1AS, that is the document you signed, right?
Yeah.
All right. On 1AS,
I don't want us to go over
That's
the
right.
whole direct examination.
I'm not.
This is supposed to be redirect.
I'm not, Your Honor. I'm specifically asking questions that are related to what the witness responded to on cross. So on cross-examination, the witness was asked whether he was allowed to craft this, whether they were his words, whether he understood them, whether he felt compelled to.
I recall.
And so what I'm asking now, and he was also asked on cross, whether he felt between a rock and a hard place.
I already answered that question.
So what is it that you
And-
want to ask him?
I believe that he testified on cross that one part was feeling between the state and the other was Fulton County Jail or going back to jail. So I'm asking him about his sentencing acknowledgments and what he has stated or agreed to within the sentencing acknowledgments and how that squares with his rock and hard place on December 28, 2022.
Okay, then ask him that, how those acknowledgements square with his rock and a hard place.
I don't think that's gonna get a quick answer, but I'll ask. Okay, so Mr. Sledge, how do your sentencing acknowledgments square with, do you understand that you
Now you
said,
thinking this no funny.
no, sir, I don't. Mm-mm.
You do.
Do you understand?
Because I know your question ain't funny.
It is not.
So what you laughing for?
Mr. Sledge, do you recall
Your Honor,
stating in your sentencing acknowledgments?
I don't recall.
Okay. Well, you have the paper in front of you. Would you please look at it to refresh your memory?
They still don't refresh my memory.
Your Honor, the state tender states Exhibit 1AS as evidence of a prior past recollection recorded. Yes, it was, and it was agreed to.
I object as well, Your Honor. This is not past recollection recorded.
It
And
is.
past recollection recorded does not come into evidence. I have to get you the code section.
You're right, it doesn't. He read it into the record.
That's exactly right.
We already read it into the record though, and not we, but you already read it into the record once.
Your Honor, I'm asking, all right, fine. Mr. Sledge, do you understand that you agreed that if you fail or refuse to testify to any fact that you acknowledged in this plea agreement, that such failure or refusal nullified any promise by the DA to null pros count 30 of the indictment.
Objection asked and answered.
Sustained. We've already established that he adopted all of those things.
So understanding that as of last week, you understood the sentencing acknowledgments, it did not place you in what you called between a rock and a hard place with Mr. Sharp, as far as coming in here and testifying to something different than what you put in the factual acknowledgments.
I came, from my understanding, I would be able to explain the things that you wouldn't change.
Mhm.
That was from my understanding.
Okay.
So now I'm in here testifying my truth and not what you put on paper and your answer. These is not my answers on this paperwork. Yeah, I did sign it, but if you would have came to me personally, like I think you should have did, and asked me this yourself, I would have told you no.
Did you testify that lay low were my words and not yours when I asked you on direct examination about defendant Williams giving YSL members money to lay low after the murder of Donovan Thomas?
When you asked me at that meeting, I told you he couldn't have gave YSL money to lay low because I'm the only one that stayed in Atlanta.
No.
I told you he gave me money to get out of harm's way. I borrowed $300.
I'm talking about in court last week. Do you remember saying, I didn't say lay low, those were your words?
Them is your word. I didn't say lay low.
Do
That
you
was
remember?
already on this paper. I never used the word lay low to you not one time. All this stuff that you trying to say, it was already on the paper. You changed certain things and then we agreed. And then I'm gonna be honest with you, I didn't even want to say that. I got another paper that's saying you changed number 8. It went from one thing to another thing. You don't want to red flag that.
No, I do. Actually.
Okay.
Okay, wait a minute. I just needed a minute. I just needed to catch my breath. What is happening? This is like it's the mm. It's like it's love against her own witness right now. It's a battle about these statements, and this man sound like he has been trying to be nice, and he didn't want to do you like this, Miss Love. But I got a whole nother paper that says something different. Did y'all just hear that? After he had already, if you had come and asked me about what was on this paper, and I don't even know what to say to that, because I think, child, I just needed a moment to process what is happening, because it looks like he is getting ready to light her up, or is she getting ready to light this boy up, because she's obviously into this plea agreement, these statements, and this accusation that I done did something funky with this statement on top of everything else. You know I can take your freedom, right? You playing with me. I done seen this lady point her finger at this man. I seen her take her country stance, as she said herself. Child, I just needed a second I just needed a second. She was stuttering when she couldn't even find a word. She didn't know what to, and then the defense is over there like, look, this is not what we're here for. And the judge is like, yeah, I'm with them. This is not what we're here for. Get to what you want. So she's having to kind of pivot, and she can't find the words. He is calling her out, and Love is eating her own tail. while she's threatening pulling this boy plea agreement. Child, it's just too much. It's too much to process. I just needed a minute because what he left off, he said, "Now, I didn't want to do this to you, Miss Love." Let me just back it up for a moment. All right, I'm just going to back it up just a few seconds just to get us back here before I needed my little breather. Let's go.
Sledge, do you recall
Your Honor.
stating in your sentencing acknowledgement and that's the reason that you answered yes to all the questions that you answered yes to on State's Exhibit 444 Yankee and 1AS?
I don't recall.
Having had time to think about it now, do you remember and realize that your sentencing acknowledgements placed you in peril of probation revocation if you testified inconsistently with something you said was true during your plea agreement?
I don't think I testified nothing that wasn't true today, if I recall.
Do you remember testifying on last week when I asked you specifically about portions of what you agreed to, and for you to tell me if any part of it you're now testifying is false, to label it false, and if any part of it, if it's all true, to tell me it's true? Do you remember me having that conversation with you?
I remember the conversation, but you had put so much on, I don't even recall what went on.
Do you remember me putting in front of you State's Exhibit 447Y? And
Yes. You'd like a new question? Oh, okay. Right. Whether he remembers it or not is not really the relevant matter.
Oh,
all right. Did you testify that
I never seen
number?
that. Not
I
highlighted.
give you the number.
All right.
Did you testify that number? I took it already. I put it back. State's Exhibit at 1AS. Here it is. Okay. And it's at 447. The second part. Did you testify that, looking at this, at State's Exhibit 1AS, did you testify that number 3 under defendant's factual acknowledgments is not entirely true?
No, I didn't say it was not entirely true. I think I remember I said the part of the support of YSL, and you put Kia as a robber gang member. I told you I didn't even know he was that gang at the time. And if I made a mistake anywhere else, I made a mistake.
All right. Do you remember me putting, now I have to ask, do you remember, Your Honor? Do you remember me putting State's Exhibit 444Y in front of you?
I remember you putting all these papers in front of me, but I don't like.
Do you remember me asking you to go over each number, and if one of it is true or one of it?
Oh, go ahead.
Do you remember me asking you that if all of the statement is true, to tell me and label it true, but that if any of it is not true, to call it false? Do you remember that?
I don't recall that, Ms. Love. Like I told you, you've been confusing me for so many days. You've been confusing me since I've been on the stand. So I don't know, like now, you jump from one thing to another thing. My brain don't move as fast as probably yours. I might don't learn as quick as you do. So I don't remember all this stuff. You putting all these paper in front of me ain't gonna make me remember.
Okay. All right.
So whatever you trying to get to.
All right. We're just getting to the questions. So we'll take it slow.
I don't remember.
All right. 1AS, that is the document you signed, right?
Yeah.
All right. On 1AS,
I don't want us to go over the
right.
whole direct examination.
I'm not.
This is supposed to be redirect.
I'm not, Your Honor. I'm specifically asking questions that are related to what the witness responded to on cross. So on cross-examination, the witness was asked whether he was allowed to craft this, whether they were his words, whether he understood them, whether he felt compelled to.
I recall.
And so what I'm asking now, and he was also asked on cross, whether he felt between a rock and a hard place.
I already answered that question.
So what is it that you
And-
want to ask him?
I believe that he testified on cross that one part was feeling between the state and the other was Fulton County Jail or going back to jail. So I'm asking him about his sentencing acknowledgments and what he has stated or agreed to within the sentencing acknowledgments and how that squares with his rock and hard place on December 28, 2022.
Okay, then ask him that, how those acknowledgements square with his rock and a hard place.
I don't think that's gonna get a quick answer, but I'll ask. Okay, so Mr. Sledge, how do your sentencing acknowledgments square with, do you understand that you
Now you
said,
thinking this stuff funny.
no, sir, I don't. Mm-mm.
You do.
Do you understand?
Because I know your question ain't funny.
It is not.
So what you laughing for?
Mr. Sledge, do you recall
Your Honor,
stating in your sentencing acknowledgments?
I don't recall.
Okay. Well, you have the paper in front of you. Would you please look at it to refresh your memory?
It still don't refresh my memory.
Your Honor, the state tender states Exhibit 1AS as evidence of a prior past recollection recorded. Yes, it was, and it was agreed to.
I object as well, Your Honor. This is not past recollection recorded,
It
and
is.
past recollection recorded does not come into evidence. I have to get you the code section.
You're right, it doesn't. He read it into the record.
That's exactly right.
We already read it into the record though, and not we, but you already read it into the record once.
Your Honor, I'm asking, all right, fine. Mr. Sledge, do you understand that you agreed that if you fail or refuse to testify to any fact that you acknowledged in this plea agreement, that such failure or refusal nullified any promise by the DA to null cross count 30 of the indictment?
Objection asked and answered.
Sustained. We've already established that he adopted all of those things, so.
So understanding that as of last week, you understood the sentencing acknowledgments, it did not place you in what you called between a rock and a hard place with Mr. Sharp, as far as coming in here and testifying to something different than what you put in the factual acknowledgments.
I came, from my understanding, I would be able to explain the things that you wouldn't change.
Mhm.
That was from my understanding.
Okay.
So now I'm in here testifying my truth and not what you put on paper and your answer. These is not my answers on this paperwork. Yeah, I did sign it, but if you would have came to me personally, like I think you should have did, and asked me this yourself, I would have told you no.
Did you testify that lay low were my words and not yours when I asked you on direct examination about defendant Williams giving YSL members money to lay low after the murder of Donovan Thomas?
When you asked me at that meeting, I told you he couldn't have gave YSL money to lay low because I'm the only one that stayed in Atlanta. I
No.
told you he gave me money to get out of harm's way. I borrowed $300.
I'm talking about in court last week. Do you remember saying, I didn't say lay low. Those were your words.
Them is your word. I didn't say lay low.
Do
That
you
was
remember-
already on this paper. I never used the word lay low to you not one time. All this stuff that you trying to say, it was already on the paper. You changed certain things and then we agreed. And then I'm gonna be honest with you. I didn't even want to say that. I got another paper that's saying you changed number 8. It went from one thing to another thing. You don't want to red flag that.
No, I do. Actually.
Okay.
So thank you.
Because you changed the personal knowledge and I ain't changed it.
Thank you for that.
I would have never said yes to that. When I got to the last paperwork, I thought we had an understanding of what the emails my lawyer sent you.
So do you now remember getting multiple versions of states 444Y that was changed at your request?
Not all of it.
Okay. Well, let's just show you. And you tell me which ones you remember.
Sure, they gonna make me remember them and stuff.
Okay.
I ain't gonna remember none.
So do you remember asking the state to change more than one thing on the factual acknowledgement?
A lot of things.
Do you remember the state making changes at your request?
I don't really know because I seen something different today that it wasn't what I thought it was the day I agreed.
Do you remember last week testifying that you hadn't seen any other document besides the one you signed?
I just seen them today.
Okay.
I didn't see it. My lawyer was just coming, asking me, and I guess he thought the question was gonna be changed, and I don't know. I don't think they was changed.
Okay. Well, we'll get to that. Since you won't remember, that's fine. When you were asked by Mr. Sharp about April 28th, 2015, Jeffrey Williams, he only asked you whether Jeffrey Williams was with you in addition to you and Mr. Zachary and Mr. Garlington. Is that right? Is my memory correct?
I don't recall.
Okay. Did you feel on December 28th, 2022, as able as you have felt in this courtroom this week and last week to tell the judge when you needed to do something like talk to your attorney? Did you feel as free to talk to your attorney or ask for requests to speak to your attorney then?
I don't recall.
You don't?
No.
Okay. is there any portion of what the jury saw in your December 28, 2022 testimony where you halted the proceedings? Or what wasn't seen? Did you ever halt the proceedings on December 28, 2022 to ask to speak to your attorney?
I don't even know the word you just used.
Did you ever stop and say, Judge, can I talk to my lawyer like you have today and last week?
Like I told you earlier, I ain't sitting over there. I'm sitting up here supposed to be telling my truth. And it's like you're not accepting my truth. I wasn't sitting over there in County Blues. I was sitting over there in County Blues. I'm in the free world. So it's like, I couldn't stop and say that over there.
Why couldn't you?
Because I don't understand that. But once I got up there, I thought I could. Because you told me that. You said, anything you don't understand, you didn't tell me that December the 28th, right?
Did your lawyer?
No. My lawyer didn't tell me to stop neither.
So sitting next to your lawyer, did you
My
ask
lawyer
him
didn't-
questions? Not
Already-
talking about what they were, but did you ask him questions at the table?
Once
I would ask the witness to be allowed to answer the questions.
Judge, I'm not asking him what was said. I'm asking him,
The province of the what? Oh, no, that doesn't. Overruled.
sitting at the table next to the lawyer you had known for 15 years, were you able to ask him questions?
I probably could have, but I didn't.
And in the back, when you were with the lawyer you've known for 15 years, did you ask him questions?
Yeah, I told him,
Well, if he wants to share it, it's his to share.
I don't want to share it. Okay, I don't want,
Specific about what you and your.
I don't want to share it.
And I'm not asking you what, I'm
I
asking
don't
you,
want,
did
she
you?
just said I had to share it,
She
Ms.
said you didn't have to share the content. I'm asking
I
you,
don't want to share it. I don't recall.
I'm asking you, did you ask?
I don't
lawyer-
recall. I don't recall. Here you go.
Are you saying that now because you're just frustrated?
Here you go again. Here you go again. Here you go again. Exactly.
Get information that is the subject matter of an attorney-client privilege.
Okay, I disagree. The question was, were you able to ask him questions in the back? And frankly, he answered it. Okay. Before he didn't recall, so.
Thank you, Judge. All right. When you left court last week, did you wipe your nose at the jury?
What you mean?
Just that. Did you wipe your nose at the jury?
Yeah, when you asked me to do it,
I mean, when you got off the stand?
no.
Okay.
I wipe my nose at the chair.
All right.
See, yeah. She going too far.
Until there's an objection, they just ask questions. But all these are capable lawyers. As is your lawyer, so
Yeah, but she,
I'll just call the balls and strikes.
you silly.
All right.
I swear you is.
Just one moment, Your Honor.
She's silly.
I think she's almost done.
Yeah, I hope so. Before I go back left. Cause I don't mind going left.
What do you mean you say? Go back left.
Arguing back and forth with you.
Okay.
You just being petty now.
All right. You felt differently on December 28th, 2022.
You would have changed everything I want you to change. I probably wouldn't even be going through it. You probably wouldn't.
Child, wait a minute. Just a quick break. Did y'all catch this shade? And he caught it. Now he coming back. They are getting into an argument because she said you felt differently in December 28, basically the day that you signed this plea agreement. I wasn't that then. You was my friend then, kinda. And so now he's like, yeah, but if you had done what I asked you to do, I wouldn't be up here in this. Because she came back with that little remark, but child, what is happening, y'all? Okay. I'm like, oh my goodness, this is crazy. Let's keep going.
Gave me the deal. If you'd have came and asked me, oh man, I'm sick of her, man.
I don't want to make you sick.
Well, let me take
Who are
a
you
break.
talking to right now?
Could I take a break?
Hang on just a second. Are you almost done? Because
I'm wrapping
there's
up.
some people who need a restroom break.
Could we
Yes.
just give them that break,
I
Your
need
Honor, and
one
I'll
back.
make sure that I'm on.
Give them
I'm
that,
wrapping.
yes, let's take a break right now.
I'm just gonna take a couple comments while we're on break. I'm gonna fast forward when we get done. So let's see. He called her silly. At first, I thought he was talking to the judge, but he was talking to her. He didn't got mad.
All right,
I
we'll be
agree.
in recess.
I think she really is, and it's kind of like she has been able to get away with questionable behavior. I'm trying to use my words carefully. I'm not trying to find my way into this lady courtroom. But she's gotten so accustomed to operating, in her manner. She is very, very deficit on the rules of engagement and the playbook. Like I can see that about her. Child. That was snarky when she said I wasn't like that on December 28th. Like, and at the same time, you questioning this agreement, you reminding me that you can take my freedom and I'm supposed to just sit here. Girl. I'm so tickled at your comment because it's so true. I just literally heard her say it in my head when I was reading it. Okay, everyone, try to tinkle, even if you don't think you have to go. Whew, seriously, if this man has to come back again tomorrow, I can't imagine. I pray they get done with him today. They need to get done with him today and let it be what it's gonna be. It's almost like she's trying the Rico, she's getting into the details, and now she's also trying her argument for his probation to be revoked. So it's like we're on several different stages and it's hard to keep up. But yeah, let's hope they go ahead and wrap that up and he can get a moment with his lawyer and calm himself down because he has gotten to the point where he don't care. She can get it. That's kind of like the line that he's at. And I just think about his first day when he was in there, he was so laid back, arm behind the chair, just she completely loses her own witness. And that's because of the trickery she's done. But I'm gonna get past the break and we're gonna come right on back in the courtroom. How you feeling out there, Amy? You hanging in there, girl? Woo! It's heated in this room. All right, let's keep going.
So Ms. Love, I see this email and Ms. Persfield's, she's not with us, but she's back in the office, so you can add her back to the emails when you're sending stuff. No, don't worry about it. I can do that. Do y'all know where Mr. Wright is? Anybody? Okay.
We'll step out now, Judge. Okay.
That's in place until we get Mr. Wright back. I think our Sergeant Ingram just went to retrieve him.
You're present, counsel.
Thank you. Go ahead, Ms. Love.
Believe that to everyone's delight, that's all that I have for Mr. Sledge right now.
All right, thank you. Is there any recross from any of the attorneys?
Not on the behalf of Mr. Stillwell.
Not for Mr. Kendrick.
Okay, All right.
I want to apologize to Ms. Lord, the courtroom and the jury for getting upset.
all right. Appreciate that.
Your Honor, I'd ask that Mr. Sledge not be released, but be
Okay.
excused temporarily.
Okay, you are excused. You're still under subpoena, so there's a possibility that you might get called again at some point. So somebody will let you know through Mr. Wright.
Okay,
But
thank
you
you.
are free to go.
Thank you.
All right. Ms. Love, call your next witness.
Your Honor, the state calls I believe that I will be calling a lieutenant, but if not, it will be Mr. Wright.
Okay. Yeah.
All right, we're just waiting for her to grab her next witness, which looks like it's going to be a lieutenant. And hopefully this will go a little bit better.
State calls Mr. Derek Wright.
Oh, that's old boy's attorney. That's Sledge attorney. I thought it was a lieutenant because it was the suit. Okay.
You swear affirm testimony you give the truth, whole truth, nothing but the truth? I do. See, state and spell the first and last name for the state, for the court, please. Right, Derek, D-E-R-E-K, Wright, W-R-I-G-H-T.
Good afternoon, Mr. Wright.
Good afternoon.
Forgive me for putting you on this stand. This is not a place that I know you normally reside.
Sustained.
I'm going to take these away from you. Put these over here. Mr. Wright, I will not be getting into matters of privilege. I'll just ask you a few brief questions regarding your interaction with the state as it relates to the witness that just testified.
Okay.
Okay. First of all, would you please tell the jury how long you've been practicing law?
It's a year short of 30 years, so 29 years.
And how long have you known Mr. Antonio Sledge?
At least 15, probably longer, somewhere between 15 and 20 years.
And forgive me, but were you sworn in? You were sworn in?
Yes.
Okay. And did you meet him first in your capacity as an attorney representing him, or did you know his family before you began representing him?
In a legal capacity first.
Okay. Do you know how many instances where you've had to represent Mr. Sledge in Fulton County? Without saying a number, are you aware of how many instances?
If I thought about it, I probably would come up with an accurate number.
Is it, have you had at least 10 occasions to interact with him on not criminal matters, but just matters, legal matters?
When you say occasions, are you referring to cases or just interactions? I've not represented him on 10 cases. It's far less than that.
Okay. Over the last 15 years, are you comfortable telling the jury how many cases that you had an occasion to represent Mr. Sledge?
I would say, for sake of being accurate to this one and the one they've heard about from before, and I think a misdemeanor case.
Okay.
So other than that, I would be having to really dig deep, and I think that's probably it.
Did the misdemeanor case happen 15 years ago?
Probably more like 6 to 8 years ago, give or take.
So what was the first, when you say you've been his attorney for 15 years, what was the first instance? What year was the first instance?
Again, I can't tell you. I'm not being difficult. I just don't recall. I just know that I did come in contact with him as an attorney. And then with many of my clients, I developed a relationship. So he is someone that I've considered a friend, and I know him, some of his family, and therefore I've had an ongoing interaction with him, both professional and personal, for 15 plus years.
All right. Is it fair to say he's not the only person that you represented in criminal matters?
Correct. I've represented many, many people over
Have
the
you-
years.
Have you had occasion to represent many, many people in Fulton County over the years?
Yes.
Have you had occasion where when you make an entry of appearance with respect to, say, for instance, a bond hearing, but have been required to stay on as a person's attorney?
Early on, when I first started, you had some of that because, one, often you might get onto a case and then get appointed where the county pays you to stay with the client.
Okay.
So early on, there was sort of an advantage to getting on early, and then you could stay on if the client either retained you privately or the county paid you. Later on, that changed, and more emphasis was put on public defender and contract attorneys and other stuff. So I would say in the last 10, 15 years, not so much.
So if you signed on to represent a person in the last 10 or 15 years for one thing and wanted to withdraw, the courts have allowed you generally to do that?
Generally, it depends where you are. If you're in Toombs County, Toombs County don't let you withdraw. Once your name hits the paper, you're the attorney regardless of whether you get paid or not.
Okay.
There's some other counties like that.
Okay.
Fulton is generally pretty liberal, where Fulton, if you and the client come to a disagreement or if money, Mr. Green doesn't show up, that also is a reason that you can sometimes get out of a case. So from that standpoint, Fulton is a little more understanding that sometimes the attorney and client have to go separate ways.
Without getting into the specifics of what you may have shared with your client, unless he waives it and you've been given permission to, and you'll have to tell me if that's the case.
Well, I'll tell you now, he has not waived attorney-client privilege.
That is fine.
So I am restrained by the laws
That's
of our
absolutely
state.
okay. Okay. So without getting into anything that is privileged information, would you tell the jury if information that is said between you and your client in the presence of others, such as Lieutenant Lancico, a lawyer from the state, whether that information is considered privilege?
It's a two-part answer.
Yes.
from an attorney-client privilege standpoint, that conversation may not be privileged because it's been said outside of me and the client, meaning there's more individuals hearing it.
Right.
From a plea negotiation and whether plea negotiations are admissible in a court of law, that is beyond the attorney-client relationship, but an admissibility issue. And therefore, the question of this conversation isn't so much an attorney-client, but whether if it's a plea negotiation or it's the furtherance of one, is it admissible?
Okay. So have you been sitting in court during the entire time that Mr. Antonio Sledge has been on the stand?
Yes. Well, there may have been a
With the
1 hour,
exception of-
1 hour short period of time one morning where I had someone covering for me, but other than that, I've
Okay.
been here the entire time.
Were you present in court when he was asked by Mr. Steele about a June 2024 meeting in Fayette between Lieutenant Lancico, yourself, Mr. Sledge, and myself?
Yes.
All right. Do you recall that meeting in Fayette County?
Yes. It was the Starbucks in Fayetteville, my place.
And how would you characterize that? First of all, how long did that meeting last?
I would estimate maybe plus or minus 40 minutes.
Okay. And generally speaking, how would you characterize that meeting, the content, the purpose?
Often when you enter into an agreement with the state, you'll be asked to come in or meet with them to discuss questions they may want to ask, subjects they may want to cover. And basically, it's almost sort of like a prep session. And from the defense side, we're also trying to get an idea. What are you going to ask us? Where are you going with things?
Mm-hmm.
So it's sort of both sides feeling each other out. And that way, when we get to court, things can sort of go smoothly. And that was sort of what we anticipated.
Mm-hmm.
And that's generally what the meeting was. To be honest, we did not get into the details of testimony as much as I am generally accustomed to. Most of it was, Ms. Love, you getting to know my client and getting a feel for him, and vice versa. So honestly, a lot of the details weren't discussed. It was more of a feel each other out kind of meeting, in my opinion.
Okay. And do you recall me asking your client about any specific details of the case or the plea that he signed on December the 28th?
There was discussion at that meeting about the plea that he had signed, a couple of videos, and again, I'm generalizing because I don't have an exact memory of everything. And again, because you didn't get into a lot of the details, like, to be sure, there was no script, there was no, here are the questions you're going to be asked. It was a very generalized kind of conversation. There was at one point, which y'all have talked about, a point where he started to share because he volunteered it.
When you say he volunteered it, what do you mean? Did I ask him something about it?
Mr. Sledge volunteered the subject of what Mr. Williams may have said to him.
Okay.
And to be clear, while it definitely wasn't what you were asking, it wasn't on the subject you wanted to cover. Therefore,
You say the subject I wanted to cover. Please explain what you mean.
You were asking, and I don't remember, to be honest, exactly what the question was, but it wasn't responsive to the question. That's why it stood out. And when you heard what he was saying about Mr. Williams, there was an immediate reaction where it was, that's not what I'm asking you,
Okay.
is what you said to him.
Uh-huh.
And he said, well, he went on, said what Mr. Williams told him.
And was that the part where he's saying he encouraged me to take? What part are you talking about?
This is what I've observed discussion in the courtroom about what he said about Mr. Williams telling him to take Woody to see the police.
Okay.
And the point was, as his attorney, as a defense attorney, I took it as that wasn't a subject you wanted to talk about and you weren't asking him about. But I can't say that I ever heard you say, don't tell the jury. It was nothing that definitive, but it was simply, that's not what I'm asking you. That's not what I've asked you to tell me. And ultimately, we sort of moved on from it, but it was just clear he very much wanted to say it, and that wasn't what you were looking for in terms of whatever the initial question was. So, but answering the issue at hand, I cannot say that you ever said, don't tell the jury.
And listening to the questions that I put upon your client during direct examination and redirect examination, where I've asked the question and his response has caused me to say, that's not what I'm asking.
Mm-hmm.
Would you characterize the interaction at that coffee shop as different than or similar to those type of interactions?
I would say one, the overall interaction at the coffee shop was pleasant. No one was arguing, yelling, screaming, anything like that. It was very pleasant. You'd ask a question, he'd provide an answer. And then even when we got to that, it still wasn't combative. It was simply, that wasn't what I asked you, or what I'll ask you. It was, again, that just wasn't a subject you were going to be asking him about. So it sort of came and went.
And when you say that's not or wasn't a subject I was going to be asking him about, is it your testimony that my response had to do with the question? Your Honor, I'm not.
Honestly, he's a lawyer. He's gonna be able to handle it. I'll give you a little leeway.
Thank you. When you tell the jury that I said, that's not what I'm asking you,
Mm-hmm.
Was your understanding that that's not what I'm asking you related to the question that I had just asked that he seemed to have not been responding to?
It was to the question. That was not the subject matter or topic you were asking a question to. Again, I did not hear it. And again, maybe I'm biased because this is what I do, but I did not hear it as an instruction to say, don't you tell the jury this, or I want you to only tell them about that. It was, that's not what I'm asking you right now. I'm not going to ask you about that. As in, so I did hear that extra part, but again, it just reinforced the idea that you weren't instructing him to limit his testimony in any way. It was just clear that wasn't a subject you planned on going into.
Mm-hmm.
So as a defense attorney, of course, yeah, my bell rang and I said, that's a hot topic, but it wasn't any ethical issue because I didn't hear you in any way try to discourage him or instruct him not to convey that information if asked.
Okay. Now, were you present or were you asked by anyone else whether that was something that had been said?
Well, I wasn't asked, but I will say I am defense bar through and through for almost 30 years. Just as I, in this situation, sort of call balls and strikes. I'm not on one side or the other. And when one side has contact with me, I'll reach out and have contact with the other side to make sure both sides are getting information. And I did reach out in contact Mr. Steele, I believe, or it may have been Max, to say, hey, we did sit down, we had a meeting. Quite honestly, there's no big secrets or anything about the meeting, but I will say there was a situation where when one subject came up, it wasn't what she was asking about, but it resonated with me because knowing what the issues of this trial are, I knew my brethren in the defense bar would want to make sure they knew, Sledge knew, or was told by Mr. Williams to take Woody to the police. Now, I imagine they may already know it, but they may not have known that Sledge had that information. So just as the state was aware of it, I wanted to make sure the defense is aware of it.
Okay, so let me just catch us up really quick with that. This is important what he's saying because Steele has a motion that he's going to argue about another Brady violation, which is withholding evidence or something, keeping evidence away that may help the client. They are entitled to give that over. And so he's explaining Steele's argument by saying, as a member of the defense bar and my brethren, we had this meeting. They may know about some part of the situation, but they don't know that this person has that information. And that's what he's addressing. How they got here. There was a Starbucks meeting. He did call Steele, and there was this whole argument about another ex parte. Miss Love gave testimony that kind of cleared that up, that it wasn't really an ex parte, and that his attorney was there, and this is his attorney. And so Mr. Steele asked Sledge, Antonio Sledge, who just got off the stand, in his cross, he asked him about that. I'm gonna get to your comment. I don't know, but it may be coming. I don't know. But he also said that he tried to tell Miss Love a piece, which is what they're getting into. He tried to tell that to her, and she told him, I didn't ask you that, don't, and I'm not going to ask you that on the stand. He interpreted whatever that piece was, he interpreted to mean that he should not tell the jury. And they got into a whole debate about it. She wasn't able to pin him on it, in my opinion. There really is a deficit in understanding, in my opinion. And so she didn't get any leeway. She had to move on. And so now she's calling him, and that's his testimony. So BJ asks, why won't the judge give a mistrial? This is appalling to me. I don't know why. I think they're getting really close, especially with this Brady kind of thing and some more arguments that Steele has gotten. Steele doesn't really want, he was arguing today saying he didn't really want to do a mistrial, but they are leaving him no choice. And he was kind of like falling on the mercy of the court indirectly because he was giving her a prelude to his arguments. I don't know why. I guess the investment of it is probably going to turn out to be a bust anyway. And she may have to, there may be some red tape that we don't know about, like how the Supreme Court, I don't know. I think it's beyond time though to call it. And given all of this, the way this has gone with these first two witnesses, even the state had an argument about a mistrial today. They even want one, but it wasn't granted. She does. I agree. I mean, the boy had to take a break. Love typo. I got you. Yeah, she's definitely been she's gonna need a break after this case, if not a permanent break. I don't know. It's very confusing following her. It was a hard time following her, but this is important what he's saying, and I just wanted to pause there because he's getting into why he contacted the defense. She opened that door by saying, did anybody contact you? Thinking the defense contacted, but he's explaining, no, this was information that I felt like the defense should know. Now that they have this information, is the judge going to say that it's another Brady violation? The state has already been ordered to be in remedial training because they seem to not understand the Brady violation. And the Brady violation is it's a part of the rights of due process. And there were motions about a mistrial filed on that, all around this ex parte and some other stuff back in June, when Judge Glanville was recused. So let's get back to it, and we'll find another moment to take a break as it move on.
And I've also made him available so that if they wanted to question him, he could also be questioned by them. In other words, fair to both sides.
And were you present when Mr. Sledge was in communication via Zoom or some other way
Absolutely.
with Defendant Williams' attorney?
Correct. In fact, there's not been a single attorney that's contacted me, and it's only a handful of times, but they've always contacted me to talk to Sledge.
Okay.
Every attorney has shown perfect professionalism.
Were you asked by any counsel for any defendant whether the state ever instructed Mr. Sledge to not tell the jury that Defendant Williams encouraged him to go to the police?
Let me answer it in two parts. Yes, I have told them.
No, were you asked? That's the first question.
Oh, okay. Let me make sure I'm addressing the question because, us lawyers, we like to talk.
So did Mr. Steele ask you if I told Mr. Sledge, don't tell the jury that Defendant Williams encouraged you to go to the police? Did he ask you that question?
I don't recall him necessarily asking the question, but I told him my observation of that conversation. And Mr. Sledge told him his observation of that, really on the same Zoom meeting. So he actually, without having to ask it, received it from both me and Mr. Sledge. And even at that time, I said, I did not hear it that way, but if my client says he heard it that way, then he heard it that way. So it's quote unquote, two people hearing the same thing may take it a different way, especially one who is a defense attorney.
Did I inquire that of you after hearing that from Mr. Sledge? Did I ask you about that?
We have talked about it, yes.
And did you tell me that you told Mr. Steele? No, I didn't hear that.
Yeah. Well, I told Mr. Steele, I never heard you tell him, do not tell the jury. What I told you was that I've explained, I didn't hear her say that. I heard that she didn't seem to like that topic, but I can't say that I heard you instruct him. But my client insists that that's what he heard. So that's I know it's not a black and white answer, but that's the gray answer where my client has been very consistent saying, this is what he heard, but that's not what I heard. So I'm not gonna juice it up for the state or for the defense. I can only convey what I, in good faith, heard.
And is there anything in particular that you recognized or saw that made you think I did not like that topic?
Knowing the general idea of what the case is about, that ultimately the state's theory of the case that Mr. Williams.
Without getting into what you believe the state's theory of the case is, I'm asking you specifically what you observed that made you believe. And Your Honor, I'd ask.
That's not what she was asking, so no. Go ahead and ask your question.
Thank you.
I'm sorry, please go again.
I'm asking you what you observed me do or say facially, non-facially, verbally, non-verbally, that led you to believe in some way that I didn't like that topic?
The fact that you stopped him pretty abruptly, meaning as he was going into it, he sort of answered anyway. So it wasn't that you didn't yell, you didn't scream, you didn't do anything, but it was just as attorneys, what we're really good at, I know we're gonna say talking, but listening and picking up. And when I saw that all of a sudden there was sort of a screeching stop point, that's when I realized, well, maybe, and again, not knowing the details of this case, maybe.
So is that where you drew your conclusion?
Let him finish his
Yeah,
answer.
maybe that topic, that point has some meaning and some significance. And that's where my thought was, okay, well, just as something may be significant about it in talking to the state, let me also make sure I've conveyed to the defense, hey, that might be some sort of topic. And again, I didn't know what he did or didn't do because my role sort of stopped pretty early in this. So again, my thought is if I'm neutral and calling balls and strikes, I want to make sure that they also are aware that may be a topic of interest. And but nothing about your body language or your mannerisms went to anything more than just, hey, maybe there's something there that someone needs to look into.
Did I tell him that's not what I asked in a way different than you've heard me say that when he's on the stand?
No.
Okay. And when I've said that's not what I've asked, when he's been on the stand, did you draw a conclusion that that was something I didn't want him to tell the jury?
I didn't draw the conclusion, but I did draw the topic was not the topic you wanted to talk about, which of course I said, why? But it wasn't, I didn't extrapolate from that, oh, you're trying to make sure he doesn't tell the jury.
Did you ever describe the meeting that we had as one where it was supposed to be kind of a get to know you kind of meeting?
Yeah, I mean, that's in truth what it felt more like let's feel each other out, get to know each other.
And before your client offered up the information, Doug encouraged me to go tell the police or take Woody to the station.
Mm-hmm.
Had I asked him any questions leading up to that?
That was towards the later part. You had already gone through some questions. I think we had asked about video. We had asked about the history of Cleveland Ave and the formation of certain gangs, notwithstanding YSL, but even before YSL. Mm-hmm. So there had been plenty of conversation. And again, more of a get to know who Mr. Sledge is, where he's from, what part of the city, how he met folks, mm-hmm. like how he met Mr. Williams and, those kind of things. So this particular part that we've been talking about, it wasn't the beginning, it wasn't the middle, it was probably more towards the end. And maybe 10 more minutes of meeting.
Had I asked him anything about Donovan Thomas's murder?
We clarified, as we did earlier, that one, he wasn't there, wasn't involved, and clarified he doesn't have specific information helpful to the state or to the defendants, mm-hmm. About the shooting of Mr. I'm blanking out that quick.
Mr. Thomas.
Peanut. Yeah.
Okay.
I guess I know more so.
All right. Now you mentioned videos. Were you present in court when I asked your client about the Lie to Your Mama video?
Yes.
All right. Do you recall in June of this year, while we were at that Starbucks, that is your spot, where I brought up the Lie to Your Mama video?
Yes.
Do you recall whether I simply went into, there's a video where someone talking about you lie to your mama?
I remember us talking about it generally because what was being discussed, not so much stated by him, but just discussed is, this is sort of a street topic. You might pick up on any street conversation where we're talking about, hey, you might lie to your mama, your daddy, your family, but when you're in court, you got to tell the truth. But
my question to you specifically is,
weren't you finished, Mr.
yeah,
Wright?
that was it. That was it.
my question to you specifically is, do you recall me asking your client? I want to ask you about a video where they're saying you lie to your mama, you lie to your kids, and your client saying, that's not me. Do you recall that interaction specifically?
Partially. I remember the conversation and the topic. I don't remember his answer being no. I remember that conversation led to a conclusion that this is something that's just said in the street. And he didn't necessarily have a point of origin of it or this or that, but it was just something that's in the street. So that's why I can't give you an answer to both parts of your question.
Mr. Wright, do you recall me telling your client, so is the answer you don't recall him saying that's not me?
Correct.
Okay. That's okay.
I remember it being played.
Like, you remember a video being played?
I want to say, I don't know if it was played or we heard the audio.
On what?
Well, that's what I'm trying to remember because we only had phones. We may have had a laptop. Again, and I could be incorrect. That's why the safe answer is I'm going to say no, because my recollection of that specific point is not, I don't know if we simply talked about a video or if one was shown.
Okay. Do you recall me telling your client, I have a video of him saying that?
You may have, yes.
Do you recall telling your client, act as if the state is God and they know everything? They already know the answers to the questions they're asking you. So don't try to be clever, just tell the truth.
It is customary when I...
No, wait, just, I don't mind the explanation. If I said it wrong, just say, no, you didn't say that.
I don't have a specific recollection of saying that, but it's customary for me to tell my clients, when you are in a cooperating posture, when they ask you questions, assume that they know the answer to the question they're asking you, that they're asking you not just to find out information, more often than not, they're testing you. They're trying to see, can they trust you or rely on your responses? Are you going to be truthful with them? So yes, it is likely I would have had that conversation. Would I have said God or some other analogy which made sense? Something. But it's more likely that I, at some point, made sure I said words to the effect of, when they ask you questions, assume they know the answer already. This is more of a testing, not a inquiry for information. So that's why I'm saying I may not have used those exact words, but I'm sure I probably did have that exchange in terms of the concept.
And when would you find it necessary to advise your clients in such a manner?
When they are in a cooperation agreement, and once we realize, they're putting us under subpoena, we actually have to testify. And then the posture sort of changed, that it's not just, hey, we're willing to testify. It's no, you're going to testify. And if you do, understand, you have to come in, you're gonna have to tell the truth. And the state's gonna question you and ask you some things. And when they do, that's when I would say, don't think you're going to outsmart them and you're smarter than everyone in the room. You need to almost assume they already know the answer to the question. And therefore, being truthful is always in your best interest. One, it's the right thing, but two, it's the smart thing.
Prior to that meeting, had you already been made aware that your client would be testifying?
Well, yes, the purpose of the meeting was, they are going to have us testify.
Right.
So we need to meet with them and see what questions they're going to ask. And like I said, just as y'all are feeling us out, we're feeling you out to get an idea. Okay, what things are they going to talk about? Are there any issues that are going to happen? And based on the plea and the fact that there was, we'll just say, some tussling or adjusting in terms of what the state was thinking of his factual proffers and what he was thinking, I figured this would also be a good time to start to iron some of those differences out and make sure that we're all on the same page as to what he can testify to and what he can't.
So you do not recall saying that in response to my telling him that we have a video of him saying they lie to your mama and you lie to your kids and get in the courtroom and tell the God's honest truth.
I may have said, wait. That's the video you're referring to. You're asking me, did I counsel him about assume the state knows?
In response to my saying to him, I
It-
have a video of you, not anybody else I'm talking about, but I have a video of you and him sitting back smiling. And then you saying that you have no memory of that.
I may have, only because listening to the dynamics of the situation, that would have been a time it would have triggered me to say to him, hey, this is, make sure you understand, you need to be straight with them. So I don't have a specific memory, but just knowing that I've been doing this a while,
Okay.
I'm sure I probably did.
Okay. Now, back in November of 2022, did the state seek, do you recall getting an email from me asking whether your client wishes to speak with the state about the case?
I believe November 17th.
All right.
I could be wrong, but I believe that was
All right.
when I received that email.
And you might have gotten one in November 17th, but did you also give one? I'm going to show you what I had marked and provided to counsel for the defense, but I'm willing to show again as State's Exhibit 450 Yankee, if anyone wants to see it. Sure.
Oh, I left them.
Yes. I know what it is.
I still have this one. All right, we're gonna take, oh, it's okay. 10 minutes or so, maybe 15, maybe longer, who knows? To give them an opportunity to look at a couple of things. Haven't discussed everything yet, so we'll call you. You can go ahead and remain outside. We'll let you know. All right.
We have, I need a few more minutes. I've got 7 documents that I'm going through, trying to parse out what is different between each of those documents. I'm on number 5, and we're doing it together.
It might be easy. Do you want to tell them what the differences are in each document? That might make it easier. You probably know what they are. If you've gotten through 5 of them? All right, so just on between 5 and 6 and 6 and 7 then. Which would be, I guess, between 454, 455, and then 456.
Code section 24-4-410. Look at it, I don't think it applies.
I think you're correct that it does
Right.
not apply.
And so let's
right.
take that off the
Okay.
table.
All right.
I will tell you that my overall objection is that I'm opposed to any of these documents coming in for a couple of reasons. And I know what the state has described them to be, that these are correspondences between the state and Mr. Wright in regards to this evolving, allegedly, plea agreement. I'll state for the record that the one thing I do have is an email, the initial email from the state to Mr. Wright. I don't see, and we've not been provided, and the state can let me know whether they have them, any responses, email responses from Mr. Wright. They would kind of inform us as to, well, what are the discussions that are going back and forth. So I don't know what Mr. Wright's responses are. If he, for example, sends some suggestions as to this is what I want changed, or this is what my client says. So I just don't, I can't address that. But in addition to that, my recollection from Mr. Sledge's testimony ultimately is that he indicated that there were changes made to the agreement, that he suggested changes, or he told his attorney that some things needed to be changed, and the state declined to change some, and they did change some. He ultimately admitted that. And so if the intent of the state by trying to introduce these documents is to show that there were changes made, well, that's not necessary, because that's come out through the testimony. Now, if they want to, if their intent is to say that there was a specific change made to maybe a specific section, that can also come out through testimony. If this witness, Mr. Wright, and I presume he does, that he would know that Section 8, and I'm using that hypothetically, Section 8 of the agreement was changed from this language to that language, and he can testify to that. But I don't think that the wholesale admissibility of all of these documents is really necessary to prove the point that the state is attempting to make. And Mr. Sledge was on the stand. He could have been confronted if the state's intention is to give him different versions and say, well, didn't this change from version number 1 to version number 2? He could have been confronted with that.
Well, I mean, she could have maybe tried, but I'm not sure that that would have been successful since these are conversations and correspondences between Miss Love and Mr. Wright, not between Miss Love and Mr. Sledge. So I don't know that. I mean, I think he even said, I don't know what got said between my attorney and her. I just know what my attorney and I said. So that wouldn't have gone very far.
Yeah.
So do you have an evidentiary objection to these, or just, I don't really want them in?
Well, they're not, I don't believe that they're prior, it's not a prior inconsistent statement. I don't know if they're trying to introduce them as impeachment. If that's the case, then I would suggest to the court that they are not prior inconsistent statements of anyone. And I would say they're not relevant, that under 403 it's a waste of time.
Okay.
It doesn't prove any point that's at issue in this case. Certainly this witness can testify to.
All right. Well, at this point, those are overruled. Are we ready for the witness now? Two minutes. You can have 2 minutes, Mr. Sharp. You can talk during his 2 minutes if you'd like to.
Your Honor, I was just trying to support Mr. Adams here a little bit because we're essentially with these different documents. The documents didn't even come through on my email. So I was sent them afterwards, but we're just trying to identify the changes. So it's just taking us a minute
Okay.
to
Well,
go through all.
you get 2 more minutes.
I didn't get an answer to that question. Maybe I didn't direct it to the state. I directed it to the
Okay,
court.
well, I don't know whether they've got the responses or not. I don't know whether they want to use them or not, but he is on the stand. So if they don't end up using them, maybe y'all can get them in if you want to.
Well, but we don't have them if they exist. And I guess I'm asking the state to indicate whether or not those items exist.
Were their responses?
I think that when Mr. Wright responded, it was via telephone call. I'll check my email to ensure that I'm not inaccurate, but
Okay.
I think that it all happened. I would send him something, we'd have a conversation, I'd send him something in response,
Okay.
but he can correct that. And if I won't touch it. But I'll check my
Okay.
emails for all emails
All
from
right.
Mr. Wright.
She'll check while y'all are doing that last bit of review.
So what are we waiting on? I guess they're going to get. Or maybe the attorney needed 2 minutes because he was on the stand.
Forward all the emails that I got from Mr. Wright.
Yeah, I definitely think we're all caught up. Sledge attorney still is on the stand, and she wants to introduce some more evidence or whatever surrounding that plea, or maybe about the corrections or whatever, something like that. And so Sharp he's not all done. That guy had a couple more pages. I think he had gotten up to 5 and 7, or 4 and 6. I think he had 2 more. So I don't know what the 2 minutes is for. It must be for the attorney to get back on the stand, because she's basically, you know, wanting his observation of her conduct. She is battling what Sledge said that she had done, which was change the statement somehow, or he gave some implications that she made adjustment to the statements to fit what she wanted versus what was actually true. So that was interesting to kind of see him on the stand with her. Like, he was answering a little bit like the witnesses. He stayed in that gray area for sure. Like, that's between you and my client, whatever he got from what you said, and he threw in his, his level of understanding versus his clients. So that was kind of interesting to watch, and also very awkward. I couldn't tell if they was friendly or foe. Let's see what the comments. Meantime, she should go ahead and forward Mr. Wright. Right, because she only gave part of the email, and they already have a Brady thing on there. But like, still has a Brady argument that's from this morning that he was just making her abreast of. He still haven't gotten into the argument because Ms. Love wasn't there yet, and he didn't want to blindside her counterpart there. So, now they're looking at evidence now that she plans to introduce, but I guess who knew that he would say those things, girl? I don't know. This is all so confusing. I want to fast forward, but it's hard to catch the attorneys when they're speaking after a break because the camera has to get over there to them. So I look for kind of like visual clues, I don't know if they're quite ready for the witness to get back on the stand because Sharp is still reviewing. And I think that particular gentleman had only gotten through a couple of the questions. So I decided I would unmute the mic and kind of tell you guys how confused I am. It's too much going on and not enough. It's such a weird place to be in this trial. Miss Love gonna have us here. Have us have to bring that guy back after talking to him or something. You just never know. I'm gonna try to see if we can catch a spot and we can move forward a little bit. Okay. Looks like it's coming. All right, at least we got some sound. Okay.
What else, Mr. Short?
I'm prepared to talk for 30 seconds, Mr. Adams.
Okay.
So
All right, go ahead, Mr. Adams.
my concern here is again, I don't know the logistics and how everyone's planning on doing this, but for instance, there is a older version that was not adopted by Mr. Sledge that was the version, Mr. Williams, could you pass me, Mr. Williams, could you pass me those? Yeah, thank you. So there's a version, the final version of version 2, which was then changed to the final version of the plea agreement. And it says under number 8, the language, as we've already heard the state read about laying low. And then it says, and during the meeting, this is the meeting at the home, defendant, which would be Sledge, personally heard a YSL associate state, I caught that N nut down bad. Now, clearly, this is something that Mr. Sledge denied happened and has been taken out of the final
Right.
plea agreement. But why? What my concern is exposing the jury to things that are not true.
So, yeah, I understand that. So I'm not sure exactly what Ms. Love's intention is with all of the different versions and whether she's gonna ask that it be, that kind of detail come in, or whether it's just gonna be, was there some additional quotation or something on there that then got removed? So Ms. Love, can you shed some light on that?
Yes, Judge. As it relates to, I think I have asked Mr. Sledge, in fact, certain things, and the objection was that it was, of course, a document that wasn't in evidence, and I should not refer to it as a prior version, where I was trying to get him to compare one document to another.
Right.
So the intent here is to show the jury that changes were made at Mr. Sledge's request and certain changes were not. And I just actually found, in response to questions from the defense about responses from Mr. Wright, and I just emailed it to them, an email from Mr. Wright to me on from back then. It looks like December 27, 2022, where he's enumerating certain things and responding to it and making recommended changes. So there are certain things that I would agree just don't need to be said. They serve no purpose. And it would be just as beneficial and serve the same purpose to say number 8 is different and I took out certain things, as it would to try and put in all that language. And that just doesn't seem necessary to put in that, some language that might be considered inflammatory, that the state thought was the case and they said no, it wasn't.
Right.
Just the very fact that they had us take out language is what the state feels is important that the jury knows.
Okay.
So no, to the extent that, and if I don't think
And I guess if you are going to tender that for admission, then that can be redacted and it can just show there was something in quotes that was then removed.
Yeah, I like that idea. And I'll, if necessary, I can really quickly go out and talk to Mr. Wright. But right now I don't expect to have him read certain things. And I know he's a lawyer, so he won't do it unless I tell him to. So I think that we're okay there.
Okay. All right.
But
was there anything else I'm sorry, did you have more?
I was just saying that I was still sending them over the emails from Mr. Wright.
All right. Was there anything else in particular that you feel like if the particular document does come in, part of it needs to be redacted out? I think we're all in agreement.
Just got an email, Your Honor, which has Brady material in it. Was just sent to us.
I haven't seen it. It didn't.
10 seconds ago. Yeah, it's
Yeah.
interesting.
I don't have it yet.
Yeah, it's kind of coming through slowly. Some of us
Okay.
quicker than others,
All
and
right.
I'm not having it printed out. And I know we've got the jury back there waiting, Judge, and I'm not trying to belabor anything.
No,
but,
no,
but this is trying to kind of handle this on the fly as we're getting emails
I understand.
in the middle of this.
Okay. Sure,
And we're-
thanks.
And we're also having 8 copies sent over for the court and the defense and.
So that must be the defendant brotherhood. The defense attorney brotherhood over there firing off these emails. That has to be somebody from the defense brotherhood. Is it? And it has to be that attorney. Because he the only one that's not there. And, well, he's a witness right now. Let me stop. But I mean, who else would have that kind of timing? She shouldn't have put him on the stand. She should have just, I said, she don't know when to quit. This lady don't know when to stop. Oh, there come my boo, y'all. Y'all see him? Okay. You saw him shake his head. You saw him shake his head. Did you guys see that? Like he was already like, when it came out about that second ex parte meeting, the
Is
second.
this response the one that is gonna change to the final? So I should be looking at the one just prior to the final when I'm looking at what he's saying?
I'm sorry, wait, what?
Which version is this in response to?
Okay, so I don't know what was just given to you, but
I get the same, this is what Ms. Love just sent to y'all or what?
Yes.
Okay, so whatever you sent over at 4:12:36 p.m. today, that was Mr. Wright's December 27th, 8:43 p.m. response. What?
Okay. So the December 27th. Let me pull it up here. Hold on. Okay. So December 27th, 8:43 p.m. No, well, that was one version. We talked more in court, so obviously there were other versions.
I'm just wondering what I should be looking at when I'm seeing what Mr. Wright's talking about.
So, if it's December 27th, 8:43, let's see, going back to December 27th to a
So
December
it's gonna be the 5:06,
It will have to be,
4:52, why?
yes, that looks right. That looks correct. And then,
All right.
December 20, but there were other versions sent back as we talked more in court the next day, December 28th. So 4:53, 4:54.
I know.
Your
okay.
Honor.
Yes.
To answer your question, this email sent by Mr. Wright on the evening of December 27th would have been between the Sledge agreement updated and Sledge agreement updated 2.
Okay. All right, that's what I thought. And is the alleged Brady, what is that? Item number 3? I hadn't read it all yet.
Sir,
but-
I haven't either, but certainly number 3 is absolutely Brady.
4 as well.
He said that it wasn't.
And it also obviously conflicts with what they kept as his factual acknowledgement. So it's clear, A, that Mr. Wright was telling them that's not true, but it's still maintained, they still kept it as a factual acknowledgement.
Okay, well, this isn't actually saying that's not true.
Well,
It's saying the real issue was,
well, the factual
which he
acknowledgement-
actually denied on the stand, but.
The factual acknowledgement says, while associated with YSL and to support and express loyalty to YSL, and then it says, and wherein on behalf of YSL, defendant threatened, and it all goes to intent and state of mind, and that's the important part of this case. No one's denying that the video was made, but what is the reason behind it? And from this email, Mr. Wright is clearly telling the state in an email on December 27th, the video may have seemed like an issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. That is Brady. That was never shared with us.
Okay, I'm not sure that that's Brady. I understand you to be saying that you think this is a denial of it being something done to support, and I don't know what the language was, support and whatever, the gang.
Your Honor, that's the crux of the case.
Yeah, no, I know. And a whole lot of this, y'all are gonna have to ultimately argue to the jury your various sides, but for this to say, it seems the video may have seemed like the issue was gang related. The real issue was the girl that a member of a rival gang was then sleeping with, that was one of the alleged gang members' girlfriends. Might make that the real issue, but it doesn't necessarily make it in no way in support of the gang. And I mean, y'all can certainly argue that, but I don't think this is the kind of thing that is like, oh, this is, plus this wasn't the ultimate version. So I don't know what went back and forth after that. He ultimately signed with his attorneys. I don't know what the advice was, but knowledge, something that said whatever the ultimate number 3 was. And y'all y'all have secured evidence from the witness that he feels like he was pressured and coerced into that, and reasons behind it. So y'all have an argument there too, but
I think we've done a good job doing that, but we did all that without the knowledge of this email, which should have been provided to us by the state. That's my only point.
And for what it's worth, the a significant portion of the state's questioning and then a redirect of Mr. Sledge focused around whether or not he had there were specific things that he had asked that they change. And so what we end up having here, what we know now from the email that we didn't have before, is that, again, going back to number 3, all right, number 3, as in its final form, talks about being associated with YSL, and talk about the video and where he's brandishing a weapon using a drive-by shooting to harm a person named Kel, a rival gang member. But the state knew, certainly when they were redirecting Mr. Sledge a little while ago, that Mr. Sledge, through his attorney, had given them the information, had specifically denied that number 3 was accurate.
all right, y'all are saying had specifically denied, and I don't read it that clearly. I don't think that's a specific denial. That's more of like I'm clarifying that this is really more about the girl than anything else, which it frankly is. So, okay. I mean, I hear what you're saying, but I don't read it that way.
If you look at number 4 also, Your Honor.
Okay.
Number 4 of the defendant's factual acknowledgments, and you got to excuse me because I'm kind of flying back and forth between the different versions.
Yeah, we all are.
But number 4 talks about on April 28th, as reflected in the indictment, that the defendant and fellow YSL associate Demiki and Garlington, I'm just reading it into the record so I can perfect it, committed a drive-by shooting using the firearm defendant wielded in the video referenced in part 3 of this section. So I'm looking at the email that we just received.
Right.
And it gives a whole total different accounting of that. Where, and of course, this is coming from Mrs. Sledge because Mr. Wright says in his email, he said he didn't know because he was cool with Peanut, who was seeing his cousin, would even be at family reunions together. He thinks shooting Peanut was not planned, but more impromptu, or at least very short or a little planning. He said he didn't know until after it was done when it came on the news. He had been watching the Patriots versus Steelers games with it, then the news reported it. You know, so this again, and what you've got is the state directing and then redirecting and challenging Mr. Sledge on these very specific factual allegations and whether or not he had told his attorney that, or whether or not he had suggested that that be changed in the agreement. And what we have here, what we know now, is that Mr. Sledge was in fact sending those, you know, correcting these very specific factual allegations, sending them to the state, and the state, well, because it doesn't appear in the factual acknowledgments, the state ignored it or they refused to make any
Okay,
changes.
so I'm not sure what y'all are looking at, because the version of number 4, factual acknowledgement number 4, that Mr. Wright is speaking to in this email that he sent on December 27, 2022 at 8:43 p.m. is, we agreed, well, at least Mr. Shart and I agreed, was Sledge agreement, the one that is 452Y, from the one that's called Sledge Agreement. Well, there are 2 that are called Sledge Agreement Updated, but this is a correspondence between 452Y and 453Y, but ultimately the end product. After the one labeled Sledge Agreement Updated that came from 12/27 at 5:06 p.m. And that one reads, on January 10th, 2015, before the murder of Donovan Thomas Jr., defendant had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. Mr. Wright's response to that is essentially, Mr. Sledge does not think the shooting of Peanut was planned, but more impromptu, or at least very short or little planning. So that clearly got changed, because our final version doesn't say they were planning to. Yes.
May I incorporate? So I cross-examined Mr. Sledge, and the state's theory is that there was a, quote, gang war starting in approximately the fall of 2014.
Right.
That escalated with the fight on January 6, 2015 of Mr. Copeland at the Club Crucial. And then it culminated and then went on steroids thereafter, after January 10th. I would have used number 4 that you just read, Your Honor, to show that there was no animosity between Mr. Sledge, who's a supposed YSL member, and Mr. Donovan Thomas, who's a supposed leader of a, quote, rival gang. The reason I say this is because I knew about it. So listen, I want to make it clear. I knew about it because I spoke with Mr. Sledge through his lawyer. So I actually asked these questions.
Right.
I didn't know about this email. But
So
the email,
go ahead, I'm sorry.
But
Go ahead.
no, don't apologize. But the email is Brady, because what the state was saying is these 2 divisions. They put, I didn't put Mr. Sledge on YSL, and that there is a total collapse between human beings. And that, to me, you know, I learned Brady to be anything that is potentially exculpatory or impeachment or mitigation. And the court has heard now, you know, Mr. Copeland said I lied about everything. That to me is Brady. The statement on this number 4 is to me Brady, because it shows that there is not animosity.
All right. So your belief about the Brady is not the part that I was talking about, but more the part that says and he here is Mr. Sledge, at least at the beginning. He said he did not know because he was cool with Peanut, who was seeing his cousin and would even be at family reunions together. Does the he change there? And is the he become somebody else was cool? Who is the he that was cool with Peanut? Do we even know? We don't.
I believe that is Mr. Sledge.
Okay. And so you think it's Brady material that Mr. Sledge was cool with Peanut?
Right, because Mr. Sledge is he's been identified before you came on the case, the bench on this case,
Okay.
as from multiple, two, definitely, maybe three, supposed gang experts saying Mr. Sledge is part of this gang.
Yeah.
So to me, and it just fits into the whole, I thank you for allowing us to get these emails, but these emails it's a special duty here. And this is not the special duty, I don't believe.
Okay. So
I'd like to see all the emails from Mr.
I think she's looking and sending all that she has. Is that correct, Ms. Love?
Two things. Yes. And when the court permits me an opportunity to respond to all of this, I would appreciate that opportunity.
Okay. What was the second thing? Or one was yes, and two, you want an opportunity to respond. Okay. All right. So Mr. Sledge has been available to the defense to speak to as well. We just heard that from Mr. Wright, in fact. And so I'm sure that Mr. Sledge, if asked, would have told anybody that asked, especially the defense, what his relationship and thoughts about Peanut were. So
He did, and I even
Okay.
asked him about it, and he answered similar to this.
all right.
But that really is besides the issue. The issue is
Well-
that the prosecution has to do, there's one thing, there's a Brady duty and then there's a Brady violation. There's no violation because I knew about it and it came out of court. But there is still the duty.
Okay, a Brady, I mean, we all know what Brady material is, I hope. And if something is equally available and as easily gotten by one side as the other, that sort of takes it out of the realm of Brady.
I don't agree with that respectfully because what if I didn't do my job? It's an ineffective claim.
Well, it
and
doesn't.
the state had the duty.
All right, well, I don't.
You can't shun your duty and say, well, he has the Honorable Keith Adams, so he'll figure it out on his own. That's not, in fact, courts ask, this court, I believe, but other courts in this courthouse say, is there any Brady evidence known? Is there any evidence suppressible known by the state? And they give it to you where they're supposed to. So I don't agree that, hey, go find it for yourself.
Well, I don't read that part of number 4
And
to be Brady. Yes.
may I respond to number 3, though? I mean, the state provided us with a plea agreement with factual acknowledgments that appear on its face to be Mr. Sledge
Mhm.
acknowledging certain things were done on behalf of YSL to further YSL. I don't have equal access to Miss Love's emails with Attorney Wright that she has.
Mhm.
So clearly, that email correspondence between Mr. Wright and Miss Love, which was never handed over until a few minutes ago, it contradicts and it impeaches those factual acknowledgments that Antonio Sledge signed. Now, I'd like to think that I do everything I can as a defense attorney, but I don't think it's unreasonable that a defense attorney would read the factual acknowledgments signed by a cooperating witness and accept that that is going to be their stance when they come and testify. And
Well, lucky for y'all, it wasn't his stance.
well, but I don't think that makes us getting it this last minute any less problematic.
Well, I'll just say that if the state has an open file, then none of these arguments ever even come up. Now, I know that that is your, something that y'all in your office can make a decision about, but open file would, just exactly what I said. So, okay, Ms. Love, what do you want to respond to? What do you feel like there still needs to be a response to?
Your Honor, I think that the court sort of encapsulated the position that I have pretty well. So you sort of took away the many of the responses that I had. And so, in as much as anything else that Mr. Wright sent to me is being printed out, I think we have them all printed out. I'm going to send them over and disseminate to the
All right.
counsel for the defense and to the court.
Okay, thank you.
Do I understand that to mean that there are more coming?
It sounds like it. Should I just send the jury home for the day? Okay. Can you release them for the day? Tell them they're under the same instructions they always are. Thank you. They're always here at 9.
I'm having a hard time understanding why she don't have an issue with this. Like, I'm trying to, because I like to see both sides, and I know she has to manage both sides, and they have their rights. But I just don't understand why having that piece.
And I'm just going to put on the record that in terms of what is and is not Brady, I mean, the Brady v. Maryland case establishes it, and there's all kinds of Georgia case law that sort of reiterates it. And one of the prongs is definitely that the defense did not possess the evidence, nor could the defense obtain it with any reasonable diligence.
Disagree, respect. That's a
Well, I mean,
violation.
You can disagree with it, but it's what the case law
That's a
holds.
violation. That's because the case law in an appellate opinion is saying the defendant, the accused, convicted person, the criminally accused is now complaining and wants the case reversed because of a Brady violation. And then there's a 4-part test. And one of the parts is, was with due diligence this information accessible? I'm not saying that. Before that, there's a Brady obligation. That falls upon the state, whether it's easily accessible or not. If 2 experts say different things and the state puts them both on the witness list, but doesn't give the accused to say, hey, one expert says actually it's favorable for your client, and they hold back that report, that's a Brady obligation breach. Now, the fact that I was on notice that there's another person on the witness list, you would expect me to interview the person, and I would have found out about it.
I mean, I think I understand what you're saying is that if it is exculpatory or impeaching, there is an obligation to provide it. Okay. I guess I am looking at it from the position of, if you are claiming at this point, here's another Brady violation, I have to look at what are these factors, and I don't find those factors to exist here.
And that's why I thought I always said I knew about it. So I'm not saying it's a violation, but it is an obligation of the state. We shouldn't be getting it. I should have really had this before I cross-examined Mr. Sledge. Should have had it before trial. And Brady, the way I understand it, is an ongoing obligation that triggers immediately.
Well, okay. Again, I don't read it in the same way that y'all apparently do. And I can't imagine that you would have wanted to use this particular exhibit, because if you used part of it, the rest of it could have come in, at least with regard to what's in each particular number. And the entirety of what's in number 4, I do not think would be beneficial to the defense side of the case.
So,
This exhibit, are you referring to the email
I
or
mean,
the?
not the exhibit, I'm sorry, bad word if I use that. This email from Mr. Wright of December 27th at 8:43 PM.
I would like the opportunity to decide what I'm going to use and not. How about that?
I understood. I guess we can tell Mr. Wright he can come back tomorrow too. At 9. Thank you.
Wow.
So have you, did you say you were going to print or you were going to forward the whatever other emails there were?
I have printouts.
Okay. You want to dole those out to everybody?
Yes.
Okay.
I just,
Since I gave the court a staple back.
I genuinely rock with Whitaker.
Yes. And maybe we need to get an extra stapler down here.
I generally rock with Whitaker on her rulings. The way that she's handling this about these emails, and I'm not an attorney, but it's like she is the obligation. She's not acknowledging that as a problem. And considering these people have been ordered to do remedial training on Brady, they have already been found to have violated Brady. That they are this close to doing it again at this stage in the trial. And there's so many other witnesses with these plea agreements. I'm pretty sure he's not the only one, but I mean, I could be wrong, but I know quite a few did plea agreements. Maybe his is the only one that they're kind of, calling to testify, because they did call him to testify. But I don't agree with her on that ruling. But if it is, that means that there definitely would have to be a mistrial. And they are fighting no, yes, mistrial down to the last wire. So I normally rock with her on her rulings because I understand her position so well, just in trying to keep a balance. But this one right here, I don't know, y'all. Let's keep going.
Somewhere around.
And 20.
Yeah, me and my fast forward button, honey.
How many, is this just one more email or is this a few?
This is series of emails, the emails that I got from Mr. Wright. I think I had him print out all of the ones that he sent me.
Okay. And so this will this stack include the 2 that you sent electronically or no? It's fine either way. I'm just wondering.
I think so. I think I
Okay.
asked her to send out all of them.
Okay.
Print out
All right. And you've got a copy for each of the 6 defendants and a copy for the judge?
Yes,
Okay.
and also, to the extent that I enter any of these, the copies that I'm giving to everybody, it includes everyone that I email them to. I'm going to take off that portion,
Okay.
and it will only include the email correspondence between me and
Understood.
Mr. Wright.
Thank you.
So.
She was taking so long stapling those papers. I think that they can. She's already threatened that share drive thing where they have to open it up.
Thank you.
I don't know what the solution is, but they have to have some motions, or they at least have enough to do if there is a conviction, to do an appeal or whatever with all these violations. But I just don't agree with her on that. There should be some problems for the state right now, in my opinion. So by her just kind of having this matter of fact attitude about it, it's just sending a message that I don't like to. I don't know. I feel like there should be problems for the state right now. She's already approached this subject. So was she just kind of, doing that to cross the T's, or do she really want them to make improvement on how they handle trial? But it sounds like they're not done. I have fast forwarded and I don't want to miss a piece. And there's not really any moving parts to kind of cue me. So I definitely want to hear the defense. Because, we have some other lawyers that come in sometimes that have really good arguments and they're all shuffling and reading. I love how they stick together on this defense side and have each other's backs. So they're not done arguing. I heard Steele talking, and
Your Honor,
Yes.
let's go.
let me inquire of the court, because I want to be really careful about this.
Okay.
Mr. Wright, of course, is on the stand. He's a witness. He's been sworn. He's testifying. And my general thinking would be, well, we're not really allowed to talk to him at this point.
I would think that's accurate.
Right. My thinking, though, is as we're sitting here talking about it in regards to the email exchanges, and I'm not casting aspersions on anyone. We've received what the state said that they have in their possession, although they initially said that most of the correspondence were by phone. And I don't know whether or not there are additional email correspondences that may be in Mr. Wright's possession, and maybe not in the States. And
All right.
I'm wondering if the court.
Let me suggest that if you want to send an email to Mr. Wright, copying the state and saying, if you want to identify him, we've got, the email of whatever date, whatever time. If there are any others, can you please forward them to, everybody copied, which would be all of the attorneys. You can certainly do that.
And then I'll copy the court on that email as well.
Okay.
Your Honor, may I request that the email simply request of Mr. Wright to forward everybody all the correspondence related
as
to.
well. Sure, I guess that would be cleaner.
Yes, thank you.
That's fine. If you want to be the one that sends out the email, that's fine too.
Thank you.
Okay.
That would you know what? One moment.
And you know what? Whoever sends it out, you can say, we all discussed it in court with the judge and the judge is fine with it.
Sure. We don't have any problem with the state
Okay.
sending that out. He's their witness technically at this point.
All right. So Ms. Love, if you wouldn't mind doing that this evening. Okay, great.
She's happy to provide him with this copy here that.
Yeah, if you want to do that, if that would make it easier, or if you just want to say, hey, can you send everything you've got? However you want to handle it.
I will do both.
Okay. All right. So the additional ones that we all just got handed, it doesn't look like there's much substantively that's new from what Ms. Love already had provided electronically. It's more, but it's not really new. Is there anything else we need to talk about before we break for the evening? Yes.
And then the investigator who's been in court, so I don't know if that matters, but
So will you call both of them, or?
I will call both of them. So Lieutenant Lancigo she's been tasked with specific things as it relates to this case, but I did not, at the time that we put Mr. Sledge on the stand,
have any idea you'd be calling
I didn't
either
expect
of
to
them?
have to call either one of them. But since we do, obviously there's case law that.
Yeah, it doesn't exclude them from being a witness. If you want to bring up, you've been in court the whole time, that's fine, but.
and then the next witness is what I was getting,
Yeah, so hopefully the two of them won't take the entire day, or to borrow a phrase from Mr. Steele, God forbid, more than a day. Do you have the next witness available tomorrow as well?
We are attempting to secure a person who's not trying to be secured, but who is under subpoena.
Okay.
And we also have Mr. Thomas Burnett.
Okay. So you'll have somebody available tomorrow.
We do.
Do that. Okay.
Yes.
Yes, sir.
I'm waiting for you to finish that
I'm
topic.
done. I'm done.
Yeah, the only thing I was going to request is for the other defendants who have pled out, if there are similar email communications between the state and that attorney where they were going back and forth on their acknowledgements. So, for example, for Mr. Murphy, Mr. Arnold, Mr. Stevens, Greer, Kitchens, Mr. Lee, Mr. Sumlin, Mr. Beebe, instead of waiting till the last minute or maybe not getting it at all, could we have that email communications as well?
How do you feel about that, Ms. Love?
Judge,
why don't you take a really careful look at any of those that might exist?
Okay.
And if there needs to be an in-camera inspection, there can be an in-camera inspection. If you want to just share it, you can just share it. But go ahead and take find whatever might exist and take a careful look at those, and then give us an update.
Thank you.
And thank you, Judge, for saying what I think you said. Take a look at whatever exists, because I was going to add to Mr. Weinstein and say not just email correspondences, just so we don't end up again with me saying, oh, you know what, I forgot to ask about these other correspondences. So any correspondence whatsoever in regards to those.
If y'all did snail mail, if you did text.
There you go.
Anything like that. Okay.
Thank you, Mr. Adams, for that broad document request. I appreciate that. Appreciate that. That's all.
Okay. Anything else? All right. I'll see y'all at. I mean, honestly, y'all, even when we're starting at 8:30, it's 9:30 before we pull the jury in. So I'm thinking, since we've got some stuff we might need to be discussing tomorrow, 8:30.
8 o'clock?
In the morning for all of us.
It could be at 8.
Okay.
We could do 8.
8? No, I don't want to do 8.
Okay.
I don't want to do 8:30, but no, we're not doing 8. I need my sleep. All right. See y'all tomorrow.
Yeah, I'm so annoyed. I am annoyed. I'm glad they're asking for everything, and it'll be interesting to see what happens tomorrow before court tomorrow, because this will give the defense time to kind of do a little bit more research and come in with some case law. But it sounds like she pulled rank on Steele today in that interpretation battle. Because this law thing, as I'm learning, is always subject to interpretation. And that's why there's so much room for corrupt, because the gray area there. But I'm interpreting it to mean this way, and I know y'all are interpreting it to be that way. So, no, I'm not going to acknowledge that. But she obviously is acknowledging it because she's threatening these remedial actions to the state. She threatened an open access, give them everything, but she's threatening in a way that you have to use IT to do it. She's threatening in-camera inspection of her stuff. And I'm going to tell you now, IT can tell when documents were moved, when documents have been edited. They can tell a lot in the background of those software systems. They can just run an audit on your user. And, so I don't think she has room to manipulate anything else, but I mean, we don't know. I don't know. But I wish she had given much more attention to this Brady violation. It's obviously another Brady violation. Mm, 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 mm. Listen, I'm shaking my head like my boo, Mr. Sharp. Like, wow. Because they could have used that information. But at least it's out there. I don't suspect we'll hear the last on that. They got into that interpretation headbutt Steele and the judge. And, he's going to come back with something. But that interpretation piece, it sounds like she poured rank on him. Boy, the state, boy, they can't be trusted for real. Not even their own witnesses can trust them. Anyway, I will be back at 11:30 tomorrow and start. I'll probably come into, the studio at about 11 and just start doing some recap and maybe do a little research on my own. But I won't start streaming the streaming court until 11:30, and I may just do it if I can get clever on the title of it between the two to where I don't, you know, because this is important. I think the length that the state will do and the rights that they will kind of nudge upon, and just to kind of get what they want, regardless if it's fair or not. The abuse of it all. Anyway, I'll be back at 11:30. Thank you so much, Amy, for joining me. I could not have gotten through this without you. But I am not so stressed as I was with with Woody. I'm with you on that, girlfriend. Release it all. Everything. All those corrections. Child, please. Anyway, the attorney will be back on tomorrow and I will be back to stream. Sound good. Me too. I really do hope that she reconsiders it, and we'll see what they get at it. They're going to get at it tomorrow, y'all. So I'll be back at 11:30. We'll start. And I will see you guys then. Thank you so, so much for joining me. And I will be back tomorrow. Good night.